Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Garnier, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to today's sitting of the Appeals Court. I am Rachel Hershfang, and to my right is my colleague Chris Hodgens. To my left is Paul Smyth. Together we will be your panel for the 6 cases that are on for today. Just a couple of notes before we start. We've read your submissions. Each side has only 15 minutes with no rebuttal. It will go very fast, so I encourage you to get to the point immediately so that you can make your points in the time that is allotted. If you do make your points and you still have time left, there's no extra credit for using all of your time, so feel free to end early if you feel that you've made your argument. It is our custom to break after our first 3 cases for about 15 minutes, and I suspect we will do that today. So if your cases are numbers 4, 5, and 6, just be aware that there will be a break before your cases. I think that's everything. So with that, I'll call the first case, JUAN Garnier, please correct me, versus ARBOUR and others, and whenever you're ready, sir.
Good morning, Your Honors. My name, may it please the Court, my name is JUAN Garnier. I am representing myself pro se. I am the appellant. I'm starting with the opening statement. We ask this Court to vacate the judgment and remand with instructions that the Superior Court enter default on liability as a spoliation sanction. Alternatively, vacate the judgment and order a new trial with the mandatory adverse inference instruction on the PCR, admission of Dr. Williams' 79G treating nexus, and a court-appointed neutral medical expert limited to causation damages with cost shifted to Cadaldo. 3 legal errors, each and collectively causing concrete prejudice, denied me a fair trial. The Court failed to exercise discretion on spoliation, calling it beyond the Court's purview, and left a materially false without incident PCR before the jury with no creative instruction. Under 79G, the same Dr. Williams' note was admitted, but the qualifying diagnosis, proximate cause, and disability sentences were cut with no exclusionary basis identified, while a jury received and counsel argued from the redacted packet, and ADA accommodations were denied. Moving on to spoliation, Your Honors. This is spoliation at creation, and I'd like to clarify the standard of review here because it's a little messy the way the judge ruled on this. So there's a few layers here, Your Honors, is that first, the Court ruled that spoliation was beyond its purview and treated it as only as destroyed evidence, which is a legal error review de novo.
And when you refer to spoliation, you're referring to the EMT report. Was it what was his name, McNamara?
McCauley, Your Honor.
Thank you. His report, is that your main claim on spoliation, that he didn't write, or he said the transport was without incident, which in fact, from your perspective, wasn't the case, obviously, and he admitted that on cross-examination, correct?
That is correct, Your Honor.
But there's no indication that report was ever destroyed or lost.
That is correct, Your Honor. However, my argument is that it still counts as spoliation.
And do you have a case, or what's the best case to support that argument?
Yes, Your Honor. So I'm not trying to bootstrap it here, but there's a statute, and then there's Fletcher and Scott kind of get us to spoliation. So Massachusetts EMS regulations require accurate, contemporaneous PCRs and make all responding personnel responsible for its accuracy. That's 105 CMR 170.345B. So they take full responsibility for the accuracy. That's the first part. Then we go to Fletcher treats alteration as spoliation, and Scott treats compromise evidence as spoliation. Here, that 105 CMR statute imposes statutory duty to create an accurate PCR, and EMTs take full responsibility for that accuracy. Riding without incident, when McCauley admits a small incident occurred, a failed first lift occurred, a jarring stop occurred, and my immediate report of pain from this occurred, and that I walked into the ambulance is both alteration and compromised core evidence in violation of that statute, Your Honors. Turning back to the standard of review, just to clarify that again, so the first part is that the court said it was beyond its purview. And in fact, obviously Fletcher tells us that it is within the court's purview to clarify spoliation. That's the first part. Then the other part is once we get to that framework is applied, then the remedy is treated as abuse of discretion. Here, as I outlined in my 16L letter, Your Honors, that the court just said it refused to exercise discretion at all, and that itself is another legal error. There was another off-the-cuff remark later on in the court, in a trial, where the judge said, you're asking for a spoliation and adverse inference, and it's not spoliation, but even if it was, I'm not giving it. So right there, the judge is saying that even if it was spoliation, I'm not even going to consider the prejudice, the culpability, the breach, the duty, and so that's the main error with spoliation, Your Honors. Sorry, going back to spoliation. So the defendant's main argument, one of the main arguments of the defendant's about that the cross-examination cured it, Your Honors. It did not. Cross-examination did not cure it. This was not a judgment call. It was a statutory mandate to create an accurate contemporaneous PCR. EMT McCullough testified to a small incident, immediate pain, and PCR states without incident. The opposite of his sworn testimony. When asked if that entry, this is the critical part here, when asked if that entry told readers nothing happened, McCullough stated yes, he agreed. So the defense then relied on that official documentation in closing and argued nothing happened. They waved it around as if it was accurate, as if it was true. Cross-examination cannot cure the lingering weight of an uncorrected record, official record presented as true. A judicial remedy was required so that the guided jury's weighing of that record, at minimum, an adverse inference at that moment, at that time.
And when you say at that moment, do you mean at the moment of the closing or at the moment the record was introduced or just at the moment of trial?
So there's two parts to this, Your Honor. A good question. So the judge has, I think, I'm just going to say this, I think the judge has discretion to get to that point, duty, breach, culpability, prejudice, and tailor a remedy, right? So once he heard all this evidence, even if he decided not to have an evidentiary hearing, which I requested, Record Appendix 4, page 129, I asked for that, it was denied. Even if the judge stated that it was beyond its purview, he still had to make sure that the jury did not go to the deliberations without proper weighing of the evidence, because that blocked occurrence and breach. The jury doesn't take me into the deliberation room, but they take a record with them. All right, so going to the next thing that the defense argues is the harmless error theory and why it fails, Your Honor. So respectively, it fails. Under the negligence instructions, the jury had to find breach and causation. Both are undermined by the trial errors. Element 2, breach turns as to whether an incident occurred. The jury evaluated that with the false official PCR stating without incident with no creative spoliation instruction. The defense then argued nothing happened with only the contemporaneous documentary saying no incident. A breach finding was effectively precluded. That's track 1. Track 2 is element 3, causation. The court excluded Dr. Williams' 70 treating nexus, the only clinician author link between the transport and the new L2, L3 finding. So the defense syllogism that the verdict proves the errors didn't matter is circular, respectfully. Track 1, the false PCR block occurrence and breach. Track 2, 79G exclusion block causation. These errors were not harmless. They drove the result by disabling proof on 2 essential elements, Your Honors. Interaction. Correcting only one error leaves the other one fatal. An uncorrected without incident PCR undercuts the 79G treating nexus. Excluding the 79 treating nexus leaves causation unsupported. The errors require tandem correction. And again, one of the things, the main things that the defense relied on was the imaging gap at Boston Medical Center. And that imaging gap is at least reasonably explained that by the false PCR itself. And an official without incident entry reasonably diverges triage and documentation, creating the very absence the defense now exploits at trial and now on appeal. Under De Jesus, the error is harmless only if the court can say with substantial confidence that it did not affect the verdict. On this record, where the errors impaired both breach and causation, substantial confidence is not warranted. There is at least a reasonable possibility the jury might have reached a different result had the PCR been corrected by an adverse inference instruction or creative instruction. The hallucinations references have been excluded, and the 790 treating nexus has been admitted. Respectfully, the court cannot say with substantial confidence that the verdict was unaffected. Okay, turning back to spoliation again. Because the key proof here is documentary, and this court stands in the same position as the trial court, and McCauley's admission is undisputed, this court may evaluate the mismatch directly. A remand limited to spoliation findings would compound the prejudice and let Cataldo profit further from his own spoliation, where the record is clear, the legal error established, and prejudice shown. This court has authority to order the appropriate remedy now.
And what would that be in your view?
Well, as I explained in the harmless error theory, we need to have both corrected, right? Both, the occurrence and then the causation. And Cataldo cannot profit and just say, well, we falsified, the record is inaccurate. Let's just say it's inaccurate, right? The record's inaccurate, but no doctor is saying that anything's connected. So all you can, then they can say, well, the only thing you can do is maybe pain. That is extreme prejudicial because the downstream effect is serious. And so I talk about this in my closing, but I go, the fault and liability is the only proportionate remedy, in my view, because the false PCR was the foundational statutory required record that diverted triage, suppressed imaging, and affected 7 years of downstream notes. That cascade can't be fixed with a cross, limited instruction, or a single medical entry, where the central evidence is falsified at creation and the prejudice is structurally enduring, which is the case here. Massachusetts law permits a terminating sanction. Culpability informs collaboration, but prejudice drives the remedy. Just going back to spoliation real quick, Your Honor. Cataldo concedes that the PCR was inadequate. The red brief 10 through 11. Labeling a jarring stop, a small incident, and an immediate report of pain and a failed first lift attempt as without incident is not a typo. It is a false exculpatory record the defense exploited, and the remedy must meet that prejudice, Your Honors. Now, I'm going to turn to Dr. Williams if there's no any questions for spoliation, Your Honors.
I've got one question.
Yes, sir. Yes, sir.
Your arguments have some appeal on the surface, but my concern is this. You seem to be relying a lot on getting documents in front of the jury in the spoliation issue. It seems that you effectively put that issue in front of the jury through cross-examination. So why would a document be any more helpful than what you did? That's one. And then on the other issue, on the medical records, your argument seems to assume that jurors are going to, one, read the medical records, because once they go into the jury room, you don't really know what they're going to do with exhibits. As opposed to presenting live testimony in the courtroom, you can be assured they're going to consider the live testimony. But when you get that document in the jury room, one, you don't know if they're going to look at it, and two, you don't know if they're going to understand it. If they don't have a physician to explain what's in the document, they might be lost. So maybe you can explain why the documents are so important.
I have to be quick because I'm really talking about. I
Sure.
thank you for your question. So when I did talk about the cross-examination, right, the portion why it was not enough, right? Because you're taking, when counsel is, showing the official record, says, see, it says nothing happened here. Nothing happened without incident. Then that's it's Bucci and they talk about how medical records are presumably the presumption of reliability. So they have this weight that they're accurate. If something would have happened, something would have happened, they would have written it down. That's one. So that's why it needed to be corrected, and that's why spoliation doctrine exists. So that's why. To answer your second question with Dr. Williams, so suggest goes to weight, not admissibility. And so it was nothing more technical than what defense counsel presented, which was the L4 discectomy, all these other records. And to go to your point, the jury is instructed to see all the evidence. If they don't see all the evidence, then they're not doing their job, right? And so now to understand it is that going to Dr. Williams real quick. I have 30 seconds, but going to Dr. Williams is that the word suggests in Dr. Williams' opinion affects weight, not admissibility. The cure for complexity is cross-examination for that record, and not deletion, because the statutory ruling conflates admissibility with sufficiency. 7 governs whether an opinion reaches the jury. Sufficiency is tested after the evidence closes. So that way, the closing argument is not skewed one way or the other. So that's why it's very important that it's at least admissible and sufficient. We would be here on a different discussion if it was admissible and then struck after evidence closes. But it is clearly admissible, Dr. Williams' admission, and defense counsel says that it's me that says I'm disabled. Dr. Williams says, real quick, it says that Dr. Williams says that I reviewed with him again all the imaging findings, including evidence of an annular tear and bulging at the L2, L3 level, which is new compared to his prior imaging studies, which suggests a significant traumatic event, which is likely associated with his muscle spasms. Overall, Mr. Garnier continues to be fairly disabled after his traumatic event in 11 to 2018. That is, so respectfully, that is why 7IG exists. Dr. Williams is a spine expert. He's already done the technical work, and he's just telling it in his treating nexus. His treating nexus plus my testimony plus Ron McCauley's testimony gives the jury enough to decide a but-for causation.
All right, I think we'll have to leave it there, Mr. Garnier. We have your excellent brief, and thank you so much for your presentation today.
Good morning, Your Honors, and may it please the Court. My name is Janelle Gordon, and I represent Cataldo Ambulance. I have a lot to get through, so I'm going to try to be as concise as possible for the Court. The first issue I'd like to address is spoliation. There appears to be two pieces of evidence at issue. The first is a patient care report concerning Mr. Garnier's ambulance transport. He essentially argues that the record was spoliated because it wasn't prepared adequately in the first instance. That is not spoliation. Spoliation applies where it's undisputed that evidence existed but was destroyed. Mr. Garnier's not arguing that the record was destroyed or that it was manipulated after it was created. He's simply arguing that it wasn't as detailed as he would have liked it to be.
Well, I'm not sure that's quite fair. He's arguing that it was false because there was a traumatic event in his memory, in his view, that happened to him during that transport, and the report says no incident. So if it's not spoliation, what is the recourse for someone who suffers an event like that and gets a report like this that says nothing about it?
Sure. I mean, first, the record, the fact that that wasn't included in the record, I don't think quite rises to the level of spoliation. But as Justice Hodgens pointed out, evidence regarding that alleged falsification was presented in front of the jury. So there was testimony elicited at trial that, you know, there were some details that occurred during the transport that allegedly weren't included in the patient care report. That came out at trial. So the jury had that information. The second, and I don't know if it was quite raised here, it is in the brief, there's another patient care report from an unrelated 2019 stretcher drop. Again, that record wasn't located by Cataldo. There was a lot of details missing that would have allowed them to locate that. That was stipulated on the record in front of the jury. So again, that's not spoliation. There was no evidence developed that Cataldo had destroyed.
So how do you interpret the judge's remarks that spoliation as raised by the plaintiff is beyond his purview? I mean, he's supposed to decide those issues, right? He's supposed to say whether or not it is spoliation. If it is, take certain steps. What does he mean, beyond my purview?
Well, he does unequivocally deny Mr. Garnier's motion for spoliation sanctions in the form of a jury instruction. I think what he was saying was this isn't spoliation. This is an issue for the jury to decide. As far as, whether the record was falsified or there wasn't details included in it, or the fact that this other unrelated patient care report that I would argue isn't even relevant to the case. But again, there was testimony at trial elicited on that issue. So I think that's what the judge was saying. With regards to, there's another argument raised regarding a limitation, an improper limitation of medical evidence at trial. What I'd first like to say is to the extent there was an improper limitation, it was harmless error because the court never got to the issue of damages. The jury found that Cataldo was not negligent, so they never got to the point of evaluating the medical evidence in this case.
How does that make it harmless error when, as I understand the plaintiff's argument, his argument is the record, the full record, not the redacted record, was admissible per statute under 79G, that it contained the opinion of a treating medical expert as to the proximate cause of the plaintiff's injury, and that without that piece of that evidence, the plaintiff was missing a critical link in his case between the stretcher drop, and his additional new back injuries.
Sure, Your Honor. So I would argue that goes to damages, and the jury in this case did find that.
How does it not go to liability?
Well, he's arguing that that the medical record speaks to whether his back injuries were caused by the ambulance drop, but the jury never got to that point of evaluating it. But regardless, the court did not err when it redacted or admitted redacted medical records. An expert is needed whenever causation is beyond the common knowledge and experience of a layperson, and that's exactly what we have here. This case involves a very complex back injury, and Mr. Garnier has a pre-existing history of back issues. He had multiple surgeries leading up to the incident, and so Mr. Garnier needed an expert to testify as to causation, and he didn't have that here.
What if his back had been fine and the same thing happened? Would you still say it was complex and required an expert?
I'm sorry, Your Honor, I didn't hear the full question.
Sorry, if his back was uninjured before the incident and then everything happened exactly the same, would it still be your position that an expert witness was required to draw the causative link?
Sure, Your Honor. Well, he could certainly testify that I didn't have pain before the accident and now I have pain, which he did testify to that at trial. But as far as interpreting medical records, I would argue that an expert was needed on that point. There was nothing in the medical records in this case where a doctor offered an opinion that this specific incident caused the annular tear and bulging that he describes. The only thing that comes close to that is a comment from his treating physician, Dr. Williams, that a post-incident MRI showed an annular tear and bulging, new compared to prior imaging, and I quote, suggesting a traumatic event. And I would argue that is not, an opinion as to causation. If the court had allowed that to come into evidence, it would have been prejudicial to Cataldo because the jury would have been left to speculate as to whether Dr. Williams is opining that a traumatic event caused the annular tear and bulging and which traumatic event he's referring to. There was 2 traumatic events that occurred within a week of each other. There was this ambulance transport drop, and then there was an incident at a medical facility where a patient in a wheelchair fell on Mr. Garnier. Both of those events caused increased back pain that was in the medical records and something that was testified to at trial. So to avoid this issue of a jury left speculating what Dr. Williams is talking about, the court ruled that without an expert that evidence should not come in.
But all of those are very good arguments, but I'm wondering why they wouldn't be made to a jury. Because we have a statute, and I can appreciate the appellant's frustration, because we have a statute that pretty clearly says the medical record, if is admissible, including the physician's opinion as to causation. That's pretty clear. Now, if the other side has a problem with that, the other side can bring in a physician to testify to the contrary and say, well, that's just as you just articulated. Well, there are many different possibilities here, and let me explain to you why that opinion isn't what you think it is, or isn't particularly clear, or whatever. But shouldn't it just get in front of the jury? Like, why redact it? And it kind of cuts the legs right out from under the plaintiff's case, doesn't it?
Sure. Well, I would argue again that was not an opinion as to causation. He simply makes a one-off comment that he's observing a new annular tear and bulging, and that it's suggestive of some sort of traumatic event. He doesn't identify a specific traumatic event. I would argue that all of that goes beyond the common knowledge and experience of a jury and would require an expert to interpret what Dr. Williams is saying in a way that makes sense for a jury. I would argue Mr. Garnier is not a doctor and wouldn't be in a position to do that. And so the court, 79G doesn't say that records have to be admitted in their entirety. They can certainly be, portions can be excluded on other grounds such as relevancy or prejudice, and courts do that often. And I would argue that that's what the court was doing in this particular case, was avoiding a prejudice to Cataldo.
But doesn't it put a pro se litigant at a real disadvantage, because you're not hiring the a firm who's going to front this cost, and so now the pro se litigant has to go out and hire the expert to come in and offer the opinion when it's in his view it's sitting there in the document. Why can't that just get in front of the jury?
Yeah, I don't think he would have had to have hired an expert, a formal expert. He could have called Dr. Williams to testify at trial. Had he disclosed him as an expert, he could have called him. And there actually are means available to pro ses that are navigating the legal system. For example, Mr. Garnier received funds to take the deposition of Cataldo. So there are things like that available for pro ses, and potentially he could have explored that with regards to hiring an expert if he chose to do that. There was also an argument about that the Adults with Disabilities Act was violated. The standard to raise an ADA violation is that Mr. Garnier would have to demonstrate that he notified the court of a disability, that he requested an accommodation, and he would need to demonstrate a link between the disability and the accommodation requested. First, I would argue that this issue was never raised prior to appeal, so I would argue that Mr. Garnier has waived his right to dispute this issue on appeal. There appears to be 4 events where he claims the ADA was violated. The first was at his deposition. Again, there's nothing in the record which would demonstrate that he ever notified the court of a disability or requested an accommodation either before, during, or after the deposition. It's actually unclear what accommodation he's arguing that the court should have provided to him. He also argues that it was violated at a court-ordered Rule 35 exam. Again, there's nothing in the record that he ever, to demonstrate that he ever notified the court of a disability, either before, after, or during that examination. It's also unclear what accommodation he's requesting that the court should have offered to him at that examination. He argues that the court should have explored his disability and that they should have inquired as to a potential accommodation that he might have needed before issuing sanctions for his failure to participate in that exam. But the onus is on a litigant to inform the court of a disability and to request an accommodation. It's not on the court to inquire into that. He also argues that the court failed to appoint a guardian ad litem, also in violation of the ADA. A guardian ad litem is appointed to a person deemed mentally incompetent. The fact that someone might be suffering from a mental illness does not make them incompetent. Mental incompetency is when someone's unable to understand a legal proceeding or assist in the presentation of their case. There's nothing in the record to demonstrate Mr. Garnier was unable to do that. In fact, the docket demonstrates Mr. Garnier has been a very active participant in the prosecution of his case. He has engaged in wide-ranging and vigorous motion practice. He's here today before the appeals court on his own doing. So I would suggest that there's nothing in the record to suggest that he's mentally incompetent such that a guardian ad litem should have been appointed. Finally, he argues that the ADA was violated at trial. Again, there's nothing in the record to demonstrate that he notified the court of a disability.
Let me stop you for a moment, because at the final pretrial conference, which is the day before the trial started, the judge said, "I understand you have a disability." That's at Record Appendix 251, Volume 1. There's no objection by counsel, right? Correct?
Correct, Your Honor,
And he
yeah.
allowed him to sit.
Yep.
And then later in the same, or during the trial, plaintiff asked for accommodation. He asked for a continuance of 1 day because he's in tremendous back pain.
Sure, Your Honor. I would argue that there's more than just that. There is also the requirement that there be a link between the claimed disability and the accommodation that's being asked for. And I would argue that Mr. Garnier never presented any sort of argument as to why his disability would require the court to take a 1-day recess.
Isn't it, I mean, he's representing himself and he's about to testify. Isn't it kind of self-explanatory? I'm in tremendous pain. Essentially, I can't go on. I just need 1 day. What else does he have to explain? Isn't it obvious that he's having an issue at that point?
You could argue that. I would argue that litigants often are requesting a variety of things from the court, right? We're constantly asking for different things. Mr. Garnier asked if he could remain seated during trial. I would argue that it requires more than just making a statement. I would argue that he needs to demonstrate, again, the link. But regardless, even if the court was to find that he met the criteria, that accommodation was completely unreasonable. To ask the court to take a 1-day recess would have presented an undue burden to the court, would have delayed resolution of this matter and the court's ability to address other matters.
What's the undue burden?
It would have delayed the court being able
They have
to,
1 day, and was it a 5-day trial?
5 days in total with jury selection.
That would have been undue burden to whom?
To the court, Your Honor, to the parties in the case, to the witnesses, to the jury who's serving, most of them without pay, or if they are being paid, it's significantly below minimum wage. There were a number of witnesses that were lined up that took work off and things like that. So it was an undue burden to all of the participants in the trial.
Is that finding on the record?
what finding on the record?
What you just articulated, the basis for the undue burden, is any of that on the record?
It's in my brief.
All right, thank you so much.
Thank
The
you.
case is submitted. Thank you both. Take your time, Mr. Garnier.
Thank you, thank you.
Thank you all. Our second case is Commonwealth versus Randy S. Campbell, number 23P466. I'll note, as council, I'm sure, are aware, this case is partially impounded. So please respect that order in your argument, and thank you very much for your patience. We'll hear from you.
Thank you, Your Honors. My name is Mary Rogers. As you said, I represent Randy Campbell. I want to let you know at the outset I'm very hard of hearing, so if you would be so kind as to speak a little louder than normal, and I want to make sure I answer your questions. So
Thank you for letting us know, and if we're not loud enough, please
it's
tell
getting
us.
worse.
Most things do.
So we acknowledge this was a very tragic accident, and we don't deny that Mr. Campbell is guilty of motor vehicle homicide, but this did not rise to the level of manslaughter. The Commonwealth is stretching the law, and there's 3 points about the evidence that I would like to talk about. One is about staying within the lane. 2 is the unique and unexpected nature of the danger that arose in this case. And 3 is speed. About staying within the lane, in my reply brief, actually quoted from the testimony, the only evidence about changing lanes or not, and that was that one witness testified that he moved a little bit to the left and then he jerked right. That's it. I may not have mentioned in the reply brief that in the closing argument when I was going through that, the DA at trial said he was weaving in and out and bopping. So that was said at trial, but then in the DA's brief, she, as part of her headings and within the brief, she said that he was weaving. But when you look at citations, there is no citation other than to the one that I gave, which is volume 4, page 54. So in my reply brief, I addressed that on pages 5 to 8. It's important because in the cases cited in the briefs to you, they all involved changing lanes, driving very haphazardly. Some of them involved not using the blinkers, switching lanes, going across lanes, weaving in and out. And as we all know, when we drive on the highway, you say, oh, that guy shouldn't be doing that. But it's simply, there wasn't evidence of that in this case.
Well, I think looking at pages 54 and 55 of that transcript, it's clear that the witness, first, the defendant passes him on the right, going faster than the witness who said, the witness, I think, I may misspeak, but I think this witness says he was going around 70 in the left lane. This is in a 65. So the defendant comes up very quickly on his right, gives him the finger, and then the witness testifies the car was kind of jerking between lanes. I believe he was trying to, and then there's an objection that is sustained. So everything after that obviously is, is out. And then on page 55, the witness testifies the silver car, which is the defendant's car, went towards the left a little bit and then jerked back into the right lane.
Yes, and just prior to that, the question by the district attorney was, when you say jerking between, answer so, question lanes, what do you mean by that? So then he described moving a little to the left and then jerking to the right. That was the jerking between lanes. That's all he testified to.
And the jury, again, this is a Lattimore standard, right? So are the jury entitled to conclude from that testimony that the defendant was, I'm not going to say planning because his state of mind doesn't matter, but the defendant made a movement as if he were going to cut into the left lane and then corrected back into the right lane?
Oh, yes, they one time is my point.
Okay.
He did it one time. We don't know how far he went to the left, but the witness said a little bit, and that's all. So, absolutely, yes, you could consider that, but there's many times when you go, you look at your rearview mirror and you go, oops, and you straighten yourself out. It's actually correcting, So the case is cited, like Jaguna, which was just decided. The defendant was tailgating, which didn't happen here, weaving in and out, crossed 3 lanes, went in the breakdown lane, hit a police cruiser. In DeSimone, that's the case with the boys and the girls, and switching off and going on the right side of an island mark. Going on the left of an island mark.
What about the foot up on the dashboard?
That's weird. Taking the light in the best favor of the Commonwealth, I guess we have to say that could have been happening, but I will say at the time of the accident, had that been the case at that point, we would have seen substantial, I can't imagine there wouldn't have been substantial injury to his leg, but I can't really comment much on that other than it's not against the law, but it's not wise, and it's just kind of strange. So he thought he saw that. He had never said that before. But, I don't know. But the light most favorable to the Commonwealth, I would say yes, you can definitely consider that at the time of passing, he may have. In Moore, the defendant was stopped. It was not a highway, it was residential in Brockton. The driver took off. He was driving all crazy in between traffic. It was very heavily, it was gridlock traffic. And here we had a clear sunny day in July. It was morning, it was well lit. It was a straight path. It wasn't residential. So you could consider those things. I'd like to move on to my second point, which is about the unique and unexpected danger that occurred in this case. There was a huge pothole a foot wide by a foot deep, and the police were dispatched to go out there. And what they did was they used 2 cruisers, they blocked out the right lane, traffic slowed down to 20 miles an hour. This occurred at 8 in the morning. The accident in this case occurred at 9:30. The police and the construction crew that were coming, whoever puts up signs, had ample time, an hour and a half, to put up a sign. So there was no indication that there's construction ahead, warning, you know, like you're on the highway and you see those arrows, get over. There was no indication. So that is the factor that you can consider.
Well, but I just want to make sure, you're not arguing that because the highway department hadn't managed to get, you know, flashing signs up there, that your client is not responsible. I mean, he's still responsible for looking
Absolutely.
ahead.
Yeah, absolutely. My point is, it goes to what he knew or what a reasonable person would know. And that is more the point. If there had been a warning, that would have been very helpful, and maybe it would not have occurred, the accident. Everyone would have been warned, but it didn't happen like that. It has to be a high degree of possibility of serious bodily injury or death. And I cited in my brief Scaia case and the restatement of torts. And they define that as easily perceptible danger of substantial bodily harm or death, and the chance that it will so result must be great. And we didn't have that here. And in preparing, I parceled through the testimony a little more, and I can give you citations too. There was a man that testified named John King. He lived in Pembroke, right where that exit is, and worked at a nursery. He said everybody was braking hard and quickly. That's on transcript 451. He was asked, did you see any traffic buildup? No. Then he was asked again. He did not see traffic buildup, and that's at 464 and 67. His whole testimony is 49 to 71, and he's a reasonable person.
So is Scott Wilkins, I presume, right, who testified, I did not need to jam on the brakes. We still had plenty of time to slow down. He's another one of the drivers.
He did so testify, but he also testified that he tapped his brakes, which made it more apparent to the person behind him, which was Paula Chamberlain. Mr. Flynn testified that there was traffic, but he had a GPS, and he said it was a hard stop. That's at volume 2, 144.
Doesn't the fact, though, that the defendant, from the, you know, black box, so to speak, evidence and everything, there was no effort at braking at all. I mean, he just bore right into these people who were stopped at, what, 85 miles an hour? I mean...
Yes, I was going to get to that next, the speed. He was going 86 miles an hour. I don't, you know, you can fully credit what the accident reconstructionist said. I don't dispute that. It was 73 at the time of the accident. I was going over it carefully last night. It wasn't completely clear when the accident reconstructionist testified whether he may have hit the brake at the very last minute or as a result of the accident that the brake was depressed. But it certainly was too late. It should have been sooner, but You know, it's what a reasonable person might do and might perceive, and things happen fast, and we've all made mistakes. Maybe not this mistake, but it's negligence, call it gross negligence, but does it rise to that level of manslaughter? And the legislature created motor vehicle homicide for just such a situation as this. Talking about the speed, Connor Flynn testified he was going about 70 to 75. John King, the man we were just talking about, said he was going about 70 and cars were passing him on the right. So Mr. Campbell, when you consider what was happening with the traffic, he was going about 10 to 15 miles per hour more than some of the other drivers, just to bring that down a little bit more into a different perspective. And I sent a 16L letter, my apology.
That's okay, we got it.
I thought you would be familiar with Ferris, Justice Hershfang.
Rings a bell.
You were on it, and that was a drag racing case, and he was on the wrong side, he lost control. But also there's an old Campbell case, 394 Mass 83, cited in the 16L letter, and in that case, there was a lot more than here. I'm providing it to you to compare. The defendant was speeding, driving on the wrong side of the road, failed to slow down or stop. He carried the victim on the hood of the car, and that was motor vehicle homicide that was upheld. So there has to be this huge hazard, and there has to be a conscious disregard. And Mr. Campbell did not perceive it, and there wasn't a conscious disregard. And the question is, was this, you know, would everybody know that that was there? And we have the testimony from that one witness that I spent a substantial time on, who said that he did not see it.
That's time, counsel. Let me just see if I have any questions. Seeing none, I think we'll leave it at that with your brief.
Can I mention one
Thank
quick
you.
point that's not in my brief?
No, sorry. If it's not in your brief, it's all done. Unless you want to tell us how great we are today, I think we're probably time to
Time
wrap
went
up.
quick.
Thank you.
Okay,
It always
I wish
does.
I could make that last point. One sentence?
May it please the court, my name is Melissa Johnson, Assistant District Attorney from Plymouth County on behalf of the Commonwealth. Beginning with the sufficiency of the evidence here, viewing the evidence in the light most favorable to the Commonwealth, we have a defendant who was driving at 86 miles an hour. That was 25 miles an hour over the posted speed limit. He's driving while he has his left foot up on the dashboard. He's flipping off the motorists. As he's passing them on the right, he's jerking back and forth between the lanes. And I think what's critical here is that every other motorist was able to stop in time before this pothole reconstruction. And right there, the jury heard that. Everyone was it a hard stop? Was it a not so hard stop? Either way, they were able to stop before this construction. And that's really the critical issue here. We have a defendant who went over the crest of a hill. There was a half-mile warning sign before exit 12, which is now exit 27. He had a half a mile before Paula Chamberlain's car, before straight shot downhill before Paula Chamberlain's car. So doing the math, he had over 20 seconds to brake before then, seeing the brake lights in front of him. Over 20 seconds. I'm looking at my timer here. It's 13:31. He's still not braking. We've got 15 more seconds. Still not braking, 10 more seconds. And all this time, Paula Chamberlain is sitting in her her Volkswagen, looking in the rearview mirror, stopped because she can't maneuver anywhere. There's a guardrail, there's a car to her right. She sees the defendant barreling down on her for at least 5 seconds, knowing she can't do anything about it. And he doesn't even brake, not once, until he hits her car. And the last word she said to her mother was, "I think this guy is going to hit us." That's exactly what happened. So there's absolutely no question here that there's enough evidence for this jury to have found that the defendant posed a risk of grave danger to the other motorists, that he was completely disregarding their safety when he was driving on Route 3. If there are any further questions, I just turn my attention to the sentencing issue, which I know is...
Let me just ask, before you get there, just
Of course,
I can't help but ask this question, and maybe there is no answer to it yet, but because the facts are very compelling, as set forth in the brief, and so we have medical marijuana legislation, and now we have recreational use marijuana legislation.
Yes, Your Honor.
But I understand it correctly that we still have no standard by which law enforcement can determine whether or not someone is under the influence of marijuana when they're driving.
Absolutely, Your Honor. It has been a source of frustration for law enforcement, yes. All we can show really at that point is, number one, that the person ingested marijuana, that their driving was impaired just by looking at their driving itself. Even with the field sobriety tests, which we can't really even call field sobriety tests, they are roadside assessment tests. Even those, you can't really opine a connection between the effects of marijuana and driving directly. So it is a frustration for law enforcement, Your Honor, absolutely here. And we do have, and part of the equation here, I didn't bring it up in today, although it's in my brief, is that we do have evidence that the defendant ingested a variety of substances, including fentanyl, marijuana, oxycodone, and granted, we did not meet our burden on the impairment-related charges. However, you can take that into consideration in determining the sufficiency of the evidence and the defendant's decision to drive after having ingested all of those substances as he's on the way to a methadone clinic in Weymouth.
I'm glad you brought that up, because that was what caught my eye, that there was an assortment of substances involved in this. And yet jurors are, it's a level of sophistication now, I think, with jurors, that they're looking for a number.
They're
looking for a 0.08 or a 0.12 or whatever. They're looking for something.
Right.
And right now, the government cannot give that to them.
We do not have that. It would have been helpful if we had that kind of technology at the time that marijuana was legalized, but we don't, and I think we're still a ways away from it.
Fentanyl is not legal, though.
Fentanyl is definitely not legal. Oxycodone is if it's prescribed, but fentanyl is not legal. Turning to the resentencing argument, and I know that this is somewhat of a novel argument and one that I had to make because of how thoughtful and how deliberate Justice Frenier was in sentencing this defendant. She, as you've read the sentencing transcript, took a lot of time to craft a sentence where not only the defendant would be serving quite a bit of incarcerative time because of his record and because of the facts of this case, but also she really wanted him to have a period of post-supervised release of 3 years in which she could impose certain conditions, such as drug screens, such as community service, for him not to be driving, for him not to be even applying for a license, or even applying for some kind of reprieve from his license for hardship or anything like that. She really crafted that sentence. So here we have a situation where we only have one conviction that is left standing. And I would argue the defendant, we know that the Jones case, which decided that these cases were duplicative, these charges were duplicative, came down in 1981. And yet this defense attorney never even bothered to raise that to Justice Frenier when she was sentencing, that these charges were in fact duplicative, never gave her the opportunity to craft a sentence that was appropriate on one charge.
Well, to be fair, the Commonwealth didn't raise it either, right? And so
That's
now
true.
here we are. And I guess the two questions I have for you, if I can remember them both, and they may actually be the same question, but I guess part one is, how consistent with Jones do you think you can get where you are trying to get? And the second question is, how is, looking at double jeopardy, how can you get where you're trying to get?
So I guess my point is that in terms of a waiver argument here, the defendant didn't bring up that his charges were duplicative. Now they're bringing them up. So it would seem to me patently unfair that because the defense attorney never brought it up, now he gets the benefit of a lesser sentence because we're stuck with one conviction, one sentence, 12 to 12 in a day. That's patently unfair to the Commonwealth, to the victims here. So the sentence that we would be asking is trying to give the defendant what he got before. We're not talking about sentences that were vacated because of lack of sufficiency of the evidence. They were just deemed duplicative, not even under the Morey test, but just because the legislature hadn't intended for these to be sentenced as one. We don't have any guidance from Naguna or from Jones because those were concurrent sentences. I just bring up the point that Justice Frenier really was thoughtful in the fact that she wanted this defendant, due to his record, to have some period of post-supervised release. And this would be consistent with what her original intent was. So that is why we've made the argument that we have. If you look at the Valier case, for example, at 437 Mass 366, kind of a similar situation where the defense attorney didn't bring up the fact at sentencing that, and I believe it was with felony murder charges, that there was the merger doctrine applied, and these sentences were duplicative. And in fact, that's a case where the SJC just said, look, you know, it's waived. Of course, they always consider it substantial likelihood of miscarriage of justice. But in a sense, they sort of give up the finality of their sentence at that point. If they're trying to challenge the duplicative nature of the sentencing, if they don't raise that till appeal, then the double jeopardy issue becomes less of a question. And here, where we're trying to craft a sentence that is quantitatively fair to the defendant, that's giving him the same amount of exposure that he would before, consistent with the Salop decision, consistent with the Cummings decision, where we can't sentence someone to more, but certainly give them the same amount of exposure that they had before. It seems to me that a 12 to 14 is what Justice Frenier, had the issue been flagged for her, that's what she would have sentenced this defendant to.
She hasn't retired, correct?
No, she's presiding over a trial right now, Your Honor.
We don't have to speculate as to what she would have intended. We could ask her.
We can absolutely ask her, and frankly, you can look at the sentencing transcript. It is fulsome with what she wanted this defendant to serve. In fact, she did a survey of involuntary manslaughter cases around the Commonwealth to make sure that she got it right. The only problem is that no one flagged for her that this was, in fact, not a legal sentence. And so she never had the opportunity to get it right. If there are no further questions, I ask this court to affirm the defendant's conviction. Thank you.
Thank you both. The case is submitted. The next case is Gerard Fontana and another versus the City of Boston, 2025 P 352, and whenever you're ready, counsel.
Good morning. May it please the court, my name is Neil Janowitz and I represent the City of Boston. In this case, 2 exempt Boston Fire Department management staff are seeking cash payments at retirement for unused comp days, which they received from redeeming 10 vacation days each year in exchange for cash and a comp day. That was an additional benefit under their CHOPS contract, it was called. They did not receive any comp time as regular pay for working. Based on the plain language of the CHOPS contract, settled Wage Act case law, including an opinion from the SJC less than a month ago, which I flagged in a 16L letter, and basic principles of contract interpretation, their claims fail as a matter of law. First, the Wage Act claim fails because the plaintiff's comp time is not a wage under the Wage Act. Under Nunez, the new case, Weems, Przinski, and Sullivan, all SJC appeals court and First Circuit cases, comp time plaintiffs received for redeeming vacation is additional contingent compensation, not a wage.
Can I ask what I think is probably a stupid factual question, but I became a little bit baffled in reading the briefing. My read of the contract language was that in order to redeem a vacation day, redeem means turn in, give up, hand over a vacation day, you would, in exchange for that, the plaintiffs and similarly situated people would be paid and get a comp day.
100%, that's the correct,
Okay.
it's the annual vacation redemption provision of the CHOPS contract.
And just to take that one more absurd but I think necessary step, you cannot redeem what you do not have.
Correct, that's the city's
Okay.
point. The annual vacation redemption section does not say you have to have vacation days to redeem. It's inferred. If you do not have something, you cannot redeem it. Your Honor hit it right on the head. What the provision says is annual vacation redemption up to 10 days per year at the regular rate of compensation at the time of buyback after December 31st, after 1 year of service. So what's that saying is after 1 year of service, you can redeem, from the word redemption in the title, you can redeem up to 10 vacation days and you get a cash payment for that. And then the next sentence says up to 10 compensatory days, or 10 days compensatory time, 70 hours per year upon vacation buyback. So when you buy back your vacation days, you can get up to 10 comp days.
So what we have here is, this is a conversion.
Basically.
It's really not, so in other words, the earned time was vacation time.
Correct.
Then it was converted into cash and comp time.
100%.
So there was nothing earned at that point. There was a conversion.
100%. 100%. Effectively, it allowed a CHOP, a chief of operations, who had left the union and given up union protections and union benefits and became an exempt employee, exempt from our minimum wage and overtime law. And it allowed them to obtain a cash bonus in the form of, and the right to take their days. So they could take their 10 vacation days, get 10 days worth of the cash equivalent of those 10 days, and then they would get their comp days, so they would still have the right to take the paid day off in the form of a comp day. So it was no longer vacation anymore. It was cash and the comp day. And under the law, under the Wage Act law, staying on the Wage Act claim, that's a critical distinction. The SJC in the Nunez case, I think, is the first SJC case to really nail down this point in express language. I think the best case prior to that was Sullivan from the First Circuit, but this idea was always in the Massachusetts the Massachusetts Wage Act case law. And the idea is a wage is your ordinary pay for working. When you get if you have a compensation package that gives you some other benefit that is where a requirement needs to be met beyond working, that's contingent compensation, that is not a wage. So in Nunez, what was at issue was retention bonuses. And the purpose of the retention bonuses was to convince people to stay working at a company that might not be around. It was restructuring. So, and they needed to meet 3 things in addition to working. They got their salary, but they also got the bonus. To get the bonus, they needed to work until a certain amount of time. They needed to not reduce their regular schedule, and they needed to stay in good standing. They needed to do those 3 things to get the bonus. If they didn't go do those 3 things, they didn't get the bonus. Similarly, the employees were paid out their unused sick time if they did 2 things. One, it was implicit, not use their sick time, have sick time to redeem, and not engage in conduct that would get them terminated. And since it was not regular pay for work, the SJC likened that to a contingent bonus for people who didn't use their sick time and basically did their jobs. Here, in order to end up with comp time, the CHOPs needed to have unused vacation to redeem, they needed to have the 1-year service, and they needed to redeem it. And the one piece, it's in the reply brief, the staff, the administrative staff who processed the credits of comp time said that it was connected to that redemption. It's Winnie Yam's email at 263. She's a leave processing person, according to the director of HR, Vivian Lenman's testimony. Winnie Yam was the person who processed leave at the city. She said, when she was looking at this comp time, when I credited these comp time to these plaintiffs, I had to first make sure they participated, it was the word she used, participated in the annual vacation buyback, i.e. that she used the word elected to, that they elected to redeem their vacation time. So without redeeming their vacation time, they couldn't get comp time. And that aligns with sorry, you look like, okay. That aligns with the plain language of the question, of the contract. Because the contract, when it talks about giving the CHOPs certain types of leave, it says they get it. For example, vacation. They get a set amount of vacation. It is earned depending on their years of service. Now, it doesn't say how much it is because you go to the contract, the union contract will tell you how much vacation you get based on the years of service. You get that. And the only thing you need to do to get your vacation is work. You don't need to do something else.
Under the contract, the 15 days sick leave, that's compensation.
I would say you could say under the MUI that the sick time is not, because in the SJC and MUI, it looked for conditions in 2 places. It looked at conditions when you receive it and conditions when how to use it. And what we said was, and this is dicta because it was a different type of policy. First, you can't use sick you can only use sick time when you're sick, so there's a condition there. And also, the SJC court and we pointed out that sick time is a use it or lose it. And if it's a use it or lose it policy, it's not a wage. So here, I mean, the payout of sick time, there might be an argument, but there would be a counter argument under MUI.
Now, I'm not sure if this matters in this case. I'd have to think about it. But the plaintiffs seem to be making the argument that they're being singled out here, that, and it sounds, and now I think I'm starting to understand why. It sounds like whether the city pays this or not, it's really up to the diligence of a clerk in, I guess, the payroll department who's reviewing this to flag it and say, hey, wait a minute, this is a lot of money going out the door. I don't think this is right. And it sounds like in the past, there was a lack of diligence maybe, or is there some other reason that people were getting this money?
So I would tend to agree with your initial assessment. It's not in the record. Why some were paid and some were not is not in the record. And this, as an aside, just to identify, whether or not they're entitled to payment for their comp time at retirement is separate and distinct from the Wage Act issue. Even if they're entitled to the comp time payment because other people were paid, which they are not, even if they were, it's still not a wage. And they don't get treble damages, they don't get attorney's fees. It's that question goes to the contract issue. First, address your question. Some were paid, some were not, and the reason some were paid and some were not is not in the record. It was in some of the forms, and when it was in the forms, it was paid. Some of the forms, it was not in the form, so it was not paid. Why it was not in the form is not in the record. We don't know why. And we don't know why in the record these two were caught in the process, but it is 100% possible that it was caught and this was caught in the administrative process this time. Now, to address the contract point on head, first, you can only consider the payments to the other CHOPs if the contract is ambiguous. If the contract's not ambiguous, the extrinsic evidence and the fact that other CHOPs were paid doesn't matter. You can't use that to create an unwritten contract term, and that's the Marcel Inc. case from the 30s. In that case, there was a contract between a lessor and a lessee, and it was about a window display. It must have been on the main street or something, I imagine. And the contract said the lessor could use that main window display 3 days out of the week, but the contract was silent on as to which 3 days. For 2 years, lessor let the lessee use Thursday, Friday, and Saturday. It seems like the lower court might have relied on that to create an unwritten contract term. And the SJC said, no, it's not ambiguous. You can't even look at that to create an unwritten contract term. The silence alone does not create an ambiguity. And here, the contract is silent on redeeming comp day. There's no express obligation to require the city to buy back comp time. However, that silence is arguably intentional because it provides how to redeem back vacation time each year. It provides how to that you get to buy back sick time. It provides that you get to buy back personal tours. It sets caps on those types of leave that they get to buy back. They can only carry over a certain amount of sick, personal, and vacation time. The carryover for comp time is not guaranteed. They had to get permission to carry over any comp time. And
it's not guaranteed, but it's also not limited.
It's not limited, correct, right? So under the contract, the type of leave that could be redeemed was capped. The comp time is not capped. It's 100% discretionary, and it's discretionary on the fire commissioner, who is not the auditor, the CFO, who would need to sign off on any monetary expenditures.
Is this still the contract under which CHOPs are working today?
It's not in the record, but it's been revised.
You don't have to tell me more. That was rank curiosity.
Yes.
So the only benefit to it's a little different than carrying vacation time, because vacation time has a monetary value attached to it for purposes of buyback. But if it's comp time, there's no monetary value because you've already exhausted or exchanged the monetary value. So the only value is you get to take a day off.
100%, and that's the city's position, 100%. And if it were the other case, then they would get 2 effective cash payments for their vacation days, because you get the first cash payment when you redeem it, and you get the second, and then you could bank it until retirement years later and then redeem it again for most likely at a higher rate of pay. It's like a default retirement plan if that were
Which
the
would
case.
be pretty attractive.
Which would be pretty attractive,
I mean,
but
if you're trying to attract people out of union jobs.
But it would be written. It would be written. And to that point, to be clear, that's also a significantly different contract issue versus wage issue. Because again, if it's paid and because you can put it in and bank it and let it grow, then that is not a wage. That's discretionary contingent compensation. And if you were to view it as comparing to that type of, I'm going to run out of time and not finish my point.
That's all right. You've got a great brief.
Okay, thank
Any
you.
questions? Thank you very much. Whenever you're ready, counsel.
Good morning, Your Honors. Paul Kevin Flavin. Thank you for the opportunity to advocate on behalf of retired firefighters and Chief of Operations GERARD, Jerry Fontana, and John Jack Walsh. There seems to be two issues before the court. One, whether or not comp time can be redeemed at retirement. And secondly, whether the failure to pay that at retirement is a violation of the Wage Act. The first issue, whether or not the comp time can be redeemed at retirement, there is an ambiguity in the contract. The vacation time doesn't say it can be redeemed at retirement. My brother just said it would be written if that could be the case. It would be the case. Vacation time doesn't say in the CHOPS contract that can be redeemed at retirement, but in fact it can be redeemed at retirement. Therefore, the ambiguity. If the compensatory time can be carried over, if there's a potential for it to be carried over year to year, the question becomes, if it's in the same paragraph and somehow tied, as the city argues, to the redemption of the vacation time, then why doesn't the vacation time say it can be redeemed or retired if in fact it can?
So let me pause you there just for a minute because I want to make sure that I can find things in the record that support your argument. Where in the record is there evidence that vacation time can be redeemed at retirement?
Well, I think it's common knowledge with the city of Boston has been testified.
Well, but I don't work for the city of Boston, so that doesn't really help me. So where in the record can I find evidence that when CHOPS retire, they can redeem their vacation time?
It's not just, Your Honor, it's not just CHOPS, but it's firefighters, and I'm not sure right now I can tell you where in the record that exists.
Okay.
But again, if the compensation time can be carried over year to year, the question becomes what, in fact, does happen to it at retirement. In fact, in the retirement form, there's a line item for compensation time on the City of Boston retirement form for CHOPS. Another retired employee, it's a comp time line item on when they apply for their retirement. Why would there be a line item for put in how much comp time you've accumulated? It's almost similar to the argument of whether it has to be authorized by year end by the commissioner. In the record, Your Honor, it's been established the City of Boston, in fact, carried it over every year. It was banked. Each year it accrued to the point at retirement, they have the hours that they have. That's admitted. If it wasn't authorized, it would be wiped out. Now, I guess to be belt and suspenders at the time of their retirement, they go to the commissioner, and he does it. He approves it in writing. But the fact of the matter is, it had been carried over year to year to year in the personnel people software system that keeps personnel records and payroll and such, vacation, etc. So it seems to me that, and it's also clear that the questions came up, if it's redeemed for vacation, you're getting payment for the vacation and a comp day. The evidence that was developed is also clear. That comp time is in recognition of the fact that they can't receive overtime, but that they work on-call hours outside their regular time that they get paid for. Everyone that testified indicates that. Even at the time that the position was created, the memos back at the time from the City of Boston, between the City of Boston and the fire department, that's recognized.
So would you agree that the chiefs did receive payment for their unused vacation time?
That they redeemed, yes.
That was redeemed?
That they redeemed.
Okay. And that was redeemed, and there is a provision for that, if I'm reading the contract correctly, there is a provision for that in the contract. Are you saying that's not in the contract? That's just like done by custom or something?
What is, Your Honor?
The redemption of the unused vacation time?
No, Your Honor. It's done on an annual basis. But this windfall, you know, the fact that he gets paid cash and then he's going to be paid cash again, well, I could redeem my vacation time and take my comp time the next week and get paid for it. Right? Again, I redeem my vacation time, I get a check for the vacation time, and I'm awarded 10 days of comp time. I could go to the Bahamas for 10 days, and I'm going to get paid for 10 days. So it is.
Right. I think the question is then, if you don't go to the Bahamas and instead you roll it over.
What happens to it?
Right.
Exactly. So where do we look? Number one, the retirement form has a comp line, a line item for comp.
I mean, it also has a line item for clothing allowance. I don't know what that is.
Assuming then that if you had a closing allowance, that you could claim it, it was unused at retirement.
And that's not part of the contract. Well, I guess it is. It says it's covered by the union contract,
Well,
right?
Well, Your Honor, once we look at what in fact was done, I rely, other than my clients, there were 7 shops. 2 of them didn't have comp time, didn't put in for comp time on the comp line. The other 5 did, and they were paid. But the city says we don't pay comp time at retirement, except every other shop that banked and carried over comp time, and there was no evidence there was any written approval by anyone, but they banked their comp time and they were paid it upon their retirement, other than the 2 that didn't have comp time.
All right. Let me tell you what I'm thinking, because you make a very good argument, and obviously you were very successful in the trial court, obtained a substantial amount of money for your clients. But what I keep going back to, and this is what I struggle with, is the statute, the Wage Act statute, speaks of wages earned. And so I'm struggling with this idea, if I'm understanding it right, and the city's telling me I do have it right, and you might say otherwise, but if the city buys back, redeems the unused vacation time, and then also exchanges that unused time for this comp time, that's a conversion has taken place. So in the firefighters, the chiefs have been paid for their vacation time. So where are the wages earned on this comp time? The comp time is sort of it seems like a made-up concept to just let them take some additional time off during the year.
I couldn't agree more with you, Your Honor. But but I don't think they convert the unused to comp time, the unused vacation time they redeem to comp time. I think the limit on the amount of comp time is tied to how many vacation days they redeem.
Sure, right. I know, I get that. So if it's not a conversion, what would you call it? I mean, what is the transaction? It's the vacation time is being split into 2 things. One is a pot of money, and the other is a pot of comp time to be used at some future date.
But that is given to them in recognition of the prior year, the time they've spent outside their regular work hours. They earned it. In fact, we established there was almost 12,000 during both their time they were chops, 12,000 hours. This is not an estimate my clients made. This is from the alarm system for the fire department, clocks them in and clocks them out. You know, when they're covering for the commissioner, they have to, you know, clock in, if you will, with the alarm.
I don't think that's a very strong argument for you. You have a contract that says the way you get comp time is by turning in vacation time.
That's just a
And the
tiny-
contract also says, as a CHOP, you don't get paid for covering for the commissioner and being on call. So the fact that I don't doubt that your clients did do a whole lot of overtime. It seems like it's part of the position, and I'm sure they did it. But the contract doesn't authorize payment for overtime or for acting out of grade pay.
Exactly, Your Honor. They can't get overtime. They can't get out of grade pay. If they did, this would be a lot more money. But in recognition of the fact that they're exempt from the collective bargaining agreement of the union, to attract Commissioner Finn testified to attract qualified individuals, to take that overtime away, and it's a big deal for firefighters. To take that overtime away, we had to give something to make it attractive. So, in order to compensate them, compensation time, in order to compensate them for the fact that they can't get overtime and out-of-grade pay, we're going to do this. We're going to give them comp time. Hold on. When they redeem their vacation time, we're going to give them comp time. And they can choose to use it, sort of like vacation and get paid, time off, or they can accumulate it and bank it year to year.
Yeah, but why doesn't, that seems to answer the question of, okay, as the name implies, it's comp time, we're compensating you for the extra effort you put in. So let's say this happens where you've redeemed your unused vacation time, you get cash, now you've got this comp time, now the next year comes around and you've done some extra work. You were out, instead of your regular 9 to 5 shift, you were actually out at city council meetings or something, you're covering for the chief for a week straight. The next week, you take 5 days off as comp time because, well, you know, I had to work those nights, so, you know, I want to take some time off and decompress here. I mean, isn't that what it's designed to do?
Yeah, and you would get paid for it. But the question begets itself, if I'm allowed to roll it over and bank it year to year, what happens when I retire? And of course, understand, when the chops are being asked or recruited for this position, they all know that every other chop got his compensation time redeemed when he retired. Every other chop who had comp time upon their retirement got paid for it. These gentlemen know that. Why would they think they don't get paid for it? Same contract. In the Plourde case, I think, is right on point. It's a police officer. Instead of getting paid for overtime, he could take comp time. That's what he did. He worked it, but he took comp time. He accumulated it. Upon his retirement, he wasn't paid it. This court found that's a violation of the Wage Act.
Okay, what do you say about, because again, every time you persuade me, I keep being drawn back to the language of the statute that we're bound to follow, and it's wages earned. So once they're paid out for that unused vacation time, it seems like that should be it. You've been, wages earned have been paid, and now we move on.
Right.
And you can call it comp time, or you can call it whatever time, but you're not getting paid again for that. That seems to be what the statute's saying. You get paid once.
I'm going to use my fallback position, Your Honor.
I'm sorry, what?
I'm going to use my fallback position.
Okay.
They redeem vacation time. That's earned because the statute says vacation time is a wage. They didn't work time for that. They worked a year and got whatever vacation time they got. So in the city, and I think the court's been struggling a little with, this is like a swapping of vacation for comp time.
And money.
In money. But if the comp time becomes a hybrid, if you will, in lieu of vacation time to give you some time off, vacation time is a wage under the Wage Act. So the comp time is either a replacement for vacation time or it's earned for something. Everyone testified that it was for working time outside the regular shifts, which there was a lot of. And the only way we could attract individuals and take that overtime away from them as a union firefighter was to have this benefit. But it's one of the, it's either an earned wage or it's a substitute for vacation. So if it's vacation time, it comes within the Wage Act. If it's being paid for because they can't get overtime or pay out of grade for work for time they work on call, and it's not going to city council meetings, it's going to fires. They have to be on call for fires because the commissioner's not here. If he goes to a wedding on a weekend, one of them has to be on call the entire weekend in case there's a fire because they have to respond. But it's either akin to a vacation time, which is a wage, or it's compensation for, in lieu of overtime, if I could put it that way, because they're not eligible for it, but to recognize they work hours over and above their regular shifts. I mean, there's one or the other.
Unless you have anything else, I think we have nothing else. We have both of your briefs, and the case is submitted.
Thank you very much for your attention.
All right, at this point, I think we will take our customary morning break. So we'll be gone for about 15 minutes, and then we will be back looking for the fourth case. Thank you all.
session. Please be seated.
Welcome back, everyone. We are here for case number 4 on our list, Lydia Blanche and another versus Matthew KOTOSKI and others, 24P 982. Please correct my pronunciation, and whenever you're ready.
Good morning, Your Honors. John Dombrowski on behalf of the appellants. I think a good starting point, and one that I feel was underscored by the trial court, is a description of the property in question and the characteristics of the property in question. This is a 29-acre parcel of real estate in Westminster, Massachusetts. 4 of the 29 acres used to be a gravel pit. Has not been used since my client acquired the property. The other 25 acres constitute forest land as defined by the relevant regulation. In fact, it far exceeds the requirements of forest land. The cover area to be forest land is 15%, and the regulation, Mr. Lipizan's property is approximately 70%. Mr. Lipizan is a licensed tree cutter, and for the property in question, he does have a state-approved cutting plan, forest cutting plan, and he has a certificate.
So, Counsel, maybe in anticipation of the point you're making, do you think the evidence was strong? Do you think the judge erred in finding that the primary use of that property wasn't the farming, wasn't the agriculture?
I do. In fact, the property is not being used for anything else. He's dedicated the 25 acres to a forest plan. You know, so the property on its whole is being solely used for agriculture in any sense of the word. So now we get into the myriad of definitions of what constitutes agriculture as it relates to lumber products.
Can I just pause you for a minute? I want to make sure that I'm following a thread of factual conclusions through from the ZBA to the Superior Court to us. So that in the ZBA's findings, they found that all of the wood, all of the lumber was being brought in from somewhere else. Your client's affidavit submitted in connection with the Rule 9A package in the Superior Court says, and I don't think there is any challenge to this, about a third of the wood is taken from the property, I'm sorry. And then the judge in the Superior Court in the ruling on the motion for summary judgment first sort of echoes the statement from the ZBA that the wood is all coming from elsewhere, but then about a page or so later says the majority of the wood comes from elsewhere. And I think says, but I may be misremembering, about a third of it comes from the property. What do you submit to this court is the accurate factual statement based in the record on how much or what percentage of the wood processed on site is actually grown on site?
My client's affidavit, Your Honor, indicates that approximately 1/3 of the wood is grown on site. All of the rest of the wood that he does process comes from Massachusetts, mostly from central Massachusetts.
Was your client's affidavit or your client's testimony to the same effect in front of the ZBA?
I believe so. It's been a while, but I believe so, yes. Yes, I do believe that. But getting back to the regulations where the town of Westminster has adopted and codified a right to
Before you
farm.
continue, that's Justice Hershfang's point. If the judge finds in her findings initially that all the wood comes from outside his property and then says 1/3 of the wood in this operation is from his property. At summary judgment, what standard or what finding should we agree upon? Because they're not the same, are they?
They're not the same, but the judge seemed to center her findings on all of the wood has to be grown on the property. But I do agree that it certainly is an issue of fact that is present.
But the judge finds facts when reviewing a board's decision. So it's essentially what the board found would be superseded or would be have no weight because the judge's facts will control.
Exactly, it's a de novo hearing, exactly, yes. But the bylaw, the general, so this property is in a residential 1 district. Table of uses are included in the record. My client's use of this property is allowed as a matter of right. I don't believe that's in dispute. I think what's in dispute is that main issue that whether or not all of the wood has to be grown on site. And if you look at the 102-2, which is the general bylaw of the town, it reads, "The growing and harvesting of forest products upon forest land and any other forestry or lumbering operations." Now, my brother's position on that is that means that everything has to be grown on the property. I would suggest, though, that the corollary really is more persuasive. If everything has to be grown on that property, the bylaw would just simply say that. The bylaw says the growing and harvesting of trees on forest land, of course that's an agriculture use. But then it goes on to say, and any other forestry or lumbering operations.
So is your is your position that under the definition in section 102-2 subsection 4 of chapter 102 of the bylaws, and I'm not saying this is the facts, I'm just trying to figure out the edges of your argument, if your client grew none of the trees on this property, brought all of the trees from elsewhere in Massachusetts, that would still be agriculture or farming under the bylaw?
That would be my position.
Okay.
Yes, that would be my position. It's clearly an agricultural use. And I point out to the fact that trees are a different animal. This is not a situation where you can grow corn every year, you can harvest it, replant it the next year. Most fruits and vegetables you can do that with. Trees takes decades to grow a tree. And then after the tree is cut down and is cut into hardwood, in order to be most effective, it needs to age. Otherwise, you're burning what they call green wood.
But that's just a characteristic of the particular product that your client has chosen to grow. It doesn't have any effect on the definitions in the bylaw.
I agree with that.
I mean, it could be bamboo, in which case it's going to grow like a weed and you harvest it all the time, right? Or it could be, a walnut or something that takes forever.
I agree with that, but I think also what's important to note is Mass General Law, Chapter 48, Section 3, which contains the exemption, an agricultural exemption. It talks about you cannot unreasonably regulate agricultural uses, and it talks about that during a harvest season of any particular product or crop, I'd suggest to the court that all year is really the harvest season for lumber, but at least 25% of such products for sale based on either annual sales or volume, and then I'm reading verbatim from the statute, have been produced by the owner of the land where the facility is located. It doesn't say have been produced on the land. It says produced by the owner on the land where the facility is located. And he goes on to say that 50% of your other products that you are selling, the same thing, has been produced in Massachusetts on land other than that on which the facility is located. Again, we're not talking about produced on the land. So you have a situation here where the Westminster Board, if you interpret the bylaw, the general bylaw, the way they're interpreting it, you almost have greater latitude by exercising the exemption than you do as being able to use it as a matter of right. Because they're saying, well, if you use it as a matter of right, you've got to grow it on the land. But if you use the exemption, well, now we get into this, you've got what's the primary use of the property? Clearly he's using it for agricultural purposes. Easily distinguished from every single case relied on by the trial court, where 100% of the product is brought on to the other facilities. To decide any other way is really to frustrate the purposes of zoning.
Council, of 40A, Section 3 derives its definitions of agriculture from 128.
Correct.
And 128, in part, defines agriculture as the growing and harvesting of forest products upon forest land. Gives other examples, such as raising of livestock, horses. After giving a number of examples, it then says, and any forestry or lumbering operations. Consistent with 102's mandate to reflect essentially in the preamble 40A, the language is the same, it just condenses this paragraph. But does it make any sense in your interpretation that the farmer could do all the production by simply importing products? How do you square that with the growing and harvesting of forest products upon forest land? I mean, why would they include that clause if all a farmer needs to do is import from other lands?
Well, I guess I'd answer that question with another question, which is, why would they include the omnibus clause at the end? And any other forestry or lumbering?
Well, I think perhaps to answer your own identified issue is potentially you can't have 100% production on a property because of the nature of things like tree growing. But there needs to be an anchor on the property, perhaps.
In 40A, though...
5% acre, 25%, for example, that's 40A.
And I don't mean to interrupt, Your Honor, but 40A we're talking about an exemption. There's a difference between being able to do it as a matter of right, which my client can do agriculture use as a matter of right on his property, and then there's the exemption. The exemption says even if it's not zoned for agriculture, as long as you're doing, it's your primary purpose, number one. Number two, you're at least producing the 25% from your own property. Well, but again, if you read the statute carefully, it doesn't say that. It says by the owner of the property, and you're obtaining 50% of your product from Massachusetts. So the exemption is very different from as a matter of right. Our position is we can do this as a matter of right. We're a forest. We have a forest cutting plan approved by the state. We have a
Yeah,
certificate.
but how far does that go? I mean, does that just open the door that you can set up a lumber mill and bring in lumber from elsewhere?
Well, I think
Just cutting
if
boards?
the difference between the case that's cited, I believe that might be the Rowley case. All he was doing was a lumber mill. All he was doing was a sawmill. He didn't have a forest plan. He wasn't growing or harvesting any trees. He wasn't cutting down any of his own trees. He was simply bringing lumber on and manufacturing it. I think my client's position is far removed from that.
All right, thank you very much.
Okay. Thank you.
We have your brief. We'll hear from your brother.
Thank you. Justin Parada for the appellees. First, I want to point out that 25% in the statute relates to farm stands. So there's sort of an exception within an exception when you read that part of the statute.
What part of the statute relates it to farm stands?
The 25% exception if certain things are grown on the property. There's no case or statute that says a agricultural use, if it's at least 25%, includes things brought off the property. And to be clear, we're not arguing that the stuff brought off the property in any way taints what could be harvested from the property. He's free to harvest all the trees he wants on the property and process them. But the case law up to this point, Rowley and others, makes clear that what you can't do is bring things off that property. It becomes an unallowed incidental use. The same way would be to set up a chicken plant and take chickens that are raised someplace else and harvest them into breast.
Well, I mean, I think, is there another case that you cited or you could cite where some of it is produced on site and some of it is brought in? Because I agree with you, the cases where it's all brought in are quite clear.
So there's a land court case that the judge cites. I forget the name of it. I think the second last page of her decision is the same cases that we cited. Rowley is a sawmill. Most of the things appeared to have been coming off site.
I think it was everything off-site.
Yeah, was it
in
everything? Okay.
Rowley. Yeah.
The land court case that she cites, some of the things were brought on. Oftentimes what you see in these cases is the owner makes the argument that in order to do the farming that I need to do, I need to bring things off site. I need to bring loam. I need to bring things like that. So it's part and parcel to what I'm doing on the site. That argument was never made here. The owner never said, in order to harvest the trees that grow on the site, I also have to bring these other trees off in order to harvest them. And we see this all the time. I mean, this is what owners of properties like this do. They have a little bit of a hook of an agricultural use, and they open a garbage dump or something like that and say that that's part and parcel to the agriculture.
Well, focusing on the case that's in front of us today and the bylaw that's in front of us today, so the bylaw allows, as of right, as an agricultural use, growing and harvesting of forest products upon forest land, comma, and any other forestry or lumbering operations.
Yes.
There's no requirement there that the other forestry or lumbering operations pertain only to the growing and harvesting of forest products upon forest land.
I would disagree with you only in the sense that it uses the word and instead of or. There was a time when this statute was first enacted that towns made the argument that you couldn't bring anything, that you couldn't do anything processing on the land. In other words, in this case, a town might say, you can grow the trees, but you actually can't process them. So towns amended their bylaws when other cases said, no, processing is part of it. Going back to the chicken argument, if you raise chickens, you can also process the chickens on the same land. So I agree with you, it doesn't explicitly say that, but if it were the appellant's view, that would say or, instead of processing lumber or growing lumber or the
I don't
processing.
agree with you as a matter of grammar. I think it could say or, but I think that once you have a comma and a separate clause and any other forestry or lumbering operations, that you have set off that second part in a way that perhaps is not what was intended by the town. But grammatically, it seems that a reading of this statute is at least ambiguous as to whether the products need to be grown on
Absolutely,
the land.
it could be ambiguous, but zoning boards have an entire amount of deference Ambiguity is...
What if the zoning board was wrong about the facts? I mean, it seems to, was the zoning board wrong about the facts?
Well, the facts really before the zoning, as was mentioned, once it gets to trial court, it's de novo. So really what happened at the board doesn't really matter from a factual perspective. It's only if the facts found before the trial court could support the decision made by the board. So where the board said you can't bring anything off-site, and the trial court said ambiguously maybe all of it, the record mostly was that all of it was brought from off-site. But even if it were a third,
I don't know what you mean by all of, so let's just stick to
Sure.
a third and two-thirds, because I think that's he has an affidavit that says it's a third on site, right? Is that controverted in the record? Are there facts?
yeah, so the building inspector said nothing was grown on site and that everything was being processed from off the site.
So why wasn't that a disputed material fact?
Because what the judge ruled was it didn't matter if it was a third. The judge would agree with that it wouldn't matter if it was 99.9%. He can still do the 99.9%, but he can't bring off anything and process it because it's not an allowed incidental use to what's going on the property. And part of that is supported by the public policy of this exception. An operation that, you know, the balance here is that agricultural uses get certain protections. On the other side is the impact to the neighborhood. So when you have a farm or a lumber processing operation, yes, there's going to be disruption to the neighborhood. But when you add to that trucks coming off site, things then being processed and bringing off the site, that would far outstrip the capacity of the land itself, that's sort of the balancing here. And so even if it were a disputed fact, the judge's position was clear, and you can tell by the cases that she cited, that what she was saying was anything allowed, and that was what anything brought off site wouldn't be allowed, and that was our argument. And again, it doesn't taint what he would do on the site. There's just a hard line between what's grown and processed on the site and what's brought off of the site, which isn't an allowed use. And going back to the way the board interpreted it, I agree it could be ambiguous, but unless it's arbitrary, whimsical, or capricious, the board's interpretation of its own bylaw needs to be upheld.
The challenge that I have in thinking through the board's interpretation in this case is that it was interpreting a situation in which he brought everything in. And it does seem that, you know, it's not arbitrary to me. I have no idea what my brethren think. But to me, it seems not arbitrary or capricious to say, well, no, you can't just run a wood processing operation here when you're not even growing the wood. But when you look at the record, there seems at least to be a dispute about whether some of the wood comes from the operation. So once you have that factual disconnect between what the ZBA decided and what happened in the Superior Court, it's a little more difficult to figure out how much deference the ZBA's legal conclusion is entitled to.
Respectfully, I would disagree, given that their legal conclusion was that nothing can be brought from off-site. So again, it wouldn't matter if it was 99% or 1%. Because they said nothing can be brought off-site, which is in accordance with all the other cases that have sort of addressed this. I agree that the facts, take Raleigh for instance, I agree that the facts in Raleigh were that everything was being brought off-site, but the holding was that agriculture means what this exception is meant to protect is things that happen on a property.
Well, I mean, maybe I'm looking at something different from what you're talking about. I'm looking at the findings of fact from the ZBA. And the findings are, number 3, the petitioner's operation consists of the bringing in of trees harvested off-site and processing them on-site. And then number 4, the party's operation does not meet the definition of agriculture as set out in Chapter 128, Section 1A, because the material processed on-site is grown and harvested off-site. And then 3, it doesn't fit within the bylaw for the same reason, because of the definition of agriculture. So I'm not sure how that, is that what you're saying is the decision that it has to be 100% grown on site?
No, it's not that it has to be 100% grown off-site. It's just that whatever the operation entails of bringing things off-site is not allowed under the statute or under the bylaw. Now, if the board got it wrong and said all of it, that doesn't change the board's conclusion that if it's 90% or 80% or 2%, you get to the same place. The judge didn't enjoin them from harvesting what's on the site or say they couldn't do it. So the deference is the board's legal interpretation of how this all works. And if the board thought it was 100%, it would have reached the same conclusion, which is the same conclusion the trial court reached, that if you're bringing stuff off-site, that's not agriculture. You have to get back to what the definition of agriculture is. And again, that would lead to all sorts of, people taking advantage of that. I mean, they already do enough in saying that the stuff brought off-site is necessary for what they're doing on the site. But if you could, if this were interpreted to allow things to be brought off-site and processed, then you're getting into light manufacturing and potentially heavy manufacturing. It's no longer agriculture. And I think that's the important thing to keep in mind here, what the definition is and what the purpose of this exception is.
So you're saying basically when the bylaw talks of processing, that's more in terms of like delimbing the trees to get them loaded up onto trucks so that they can go off to a mill, that sort of thing, like kind of light processing just to get the product to market.
And more than that, I think they can do whatever they need to do with it. They can do the same things they're doing to the trees that are brought on the site, to the trees that are on the site. Cut them, trim the limbs, put them into cordwood, ship it off the site. Cases have held that's incorporated into this exception. The difference is when that raw material starts coming off the site to be processed in the same way, then you're outside the bounds of what the agricultural exemption is meant to protect. And I would argue the bylaw is meant to protect the same thing. These bylaws were amended when the statute went into effect, and it's clear that it's meant to be congruent to what the statute allows. That's why that's why towns amended their bylaw to add these kind of exemptions, or to add these kind of as-of-right uses.
Counsel, based on the affidavit or the record in light most favorable at summary judgment, do you believe the judge's decision or conclusion that the plaintiff's primary use of the property wasn't this wood agriculture? Do you believe that's erroneous?
No, because first of all, no one ever said it was over 50%. The most we've heard is a third, so that wouldn't be primary. The cases talk about in order to be a primary agricultural use, it has to be over 50%.
But wait, what else was he doing on the property?
Again, it's a little bit circle, harvesting wood that comes from off the property, right? Our argument is that's not agriculture. So the same thing happening on the property to wood that grows on the property, our argument is agriculture. That same process for wood that comes off the property is not agriculture. So if that was 30 and 70, then it's no longer primary agriculture. However, we're not arguing that that in any way taints the 30% or 60, whatever it is, whatever the number is. It's the same thing. It gets a little metaphysical, I'll agree. It's the same action, but it depends on where the raw material derived from. And that's supported in the public purpose of this exemption and the cases that have addressed this.
Well, your reference of primary use, the statute 48 was amended in 2006 to include the 25%. Before that, it was primarily. So I'm not sure you're accurate in saying that the primary use has to be more than 50% in determining the primary use of the land.
The 25%, though, if what you're referring to is that governs farm stands and a different type of operation.
What part of the statute says that's limited to farm stands?
In the definition of agriculture, if you get towards it's sort of circular, but it says if 25% of the things, and then there's also the 50% Massachusetts exemption. It doesn't include things like lumber. It includes some of the other things that are included in agriculture, like horticulture, wine stands, cheese stands, things like that. It's in the definition of, again, you sort of have to parse through it. But before you get to the 25%, the words that are used as the activity, it doesn't include lumbering or other agriculture. It's limited to certain types of agriculture. And I don't have.
Well, I mean, it does say it's not a miracle of drafting.
No, none of 40A is.
But it says, before all of the very specific stuff you're talking about, it says, and by it, I mean Chapter 48, Section 3, no zoning ordinance or bylaw shall regulate or restrict the use of materials or method of construction of structures regulated by the state building code. Sorry, that was irrelevant. Nor shall any such ordinance or bylaw prohibit, unreasonably regulate, or require a special permit for the use of land for the primary purpose of commercial agriculture. And then it goes on to all the civiculture, horticulture, floriculture,
Yes. And that's where the 25% kicks in.
and then gets the 25%. But my reading of it, which admittedly is on the fly and not particularly careful, is that the 25% pertains to the whole list of stuff before it, which starts with commercial agriculture.
It's limited, again, I don't have it in front of me and I don't have it memorized, but the 25%, I'd be happy to send a letter to the court, is limited to certain subset of types of agriculture.
Okay.
And again, our argument here is anyway that this isn't agriculture because it's not grown on the
Right.
property.
Is there anything else you want to say in your last 24 seconds?
No.
Okay. Thank you both very much. The case is submitted. Our next case is Department of Children and Families and Another versus Father, 25P388. You all know the case is impounded. Please use, father, child, et cetera, no names. And my understanding is that for the appellees, we're going to hear from the department for 10 minutes and the child for 5. Is that correct? All right. Thank you very much.
Thank you. May it please the court. Attorney Morgan Russell on behalf of Father. And what I ask this court to answer today is whether an incarcerated parent can do anything to avoid the termination of their parental rights while in jail. Now here, and I spent a good amount of my brief focused on what the department failed to do for this father while incarcerated. And what I would first submit to this court is everything that Father himself did without the aid of the department. Now, he was able to stay up to date on the child and what the child's needs were through his conversations with mother. He engaged in substance abuse programs, he engaged in alcohol programs, adult and aggression programs, and parenting classes, all while being incarcerated in New York State. He also was enrolled in college by the time that trial had started and completed. All of these things he did without any help from the department. And I would suggest to this court that had him making these strides on his own, imagine what could have been done had the department made any sort of attempt at reasonable efforts in this case. Instead, what we have and what the record would show and suggest, because there's really no evidence to the contrary here, is that the department, the social worker, made very minuscule attempts. She sent maybe, I think she sent his action plan one time. She called the social worker at the jail a couple times, and then she had reached out, I believe, less than a handful of times over the entire year of this case. And this case was brought in 2023 and terminated within the year in 2024, or just over, I believe, a year from its opening. All of that time, Father was incarcerated in New York State. All of that time, the department was aware that he was incarcerated in New York State.
Well, I want to make sure, I think I remember something different, so you tell me if I'm wrong. I thought that when the case was initiated, this case, the father was actually incarcerated in Massachusetts, and then the department reached out in about July of 2023 and found he had very recently been transferred to New York.
So I think that confusion is because of the gross amount of findings related to prior care and protections in the prior history in this case. Father became incarcerated, I believe it was March of 2022, and was jailed until July of 2023 when he was transferred to New York State directly from the Berkshire House of Correction. So again, the court makes lots of references to this prior care and protection and finding that the department made reasonable efforts and had tried with Father. But again, all of those efforts, and Father has potentially lack thereof, right? He does have a long history of substance abuse, long history of criminality. He does not dispute that, but what he's trying to say is that this 2023 filing, when it happened, I was incarcerated in New York. I was doing what I had to do. I was sent letters to the department, they went unanswered. I don't know what else I can do here besides do what I can with what I am given right now in this prison, and that is what he did. And I think the court really kind of ignored that in determining that it would be in the best interest of the child to terminate Father's rights. And what she says is that, Father had no relationship, Father didn't do enough. He did these things, but they're not enough. And if that's not enough with him doing these things on his own, what are we going to say to other incarcerated parents? Are they going to be in jail when their child is removed from the other primary parent and say, well, too bad, we're going to trial, we're going to terminate right now? There's nothing you can do because you're in jail? Because if this termination is affirmed, that's exactly what this court is telling incarcerated parents, is that there's nothing for you to do. You're in jail. You did this to yourself, and now you can't step up for your child despite the other parent floundering.
So there did come a point when Father's counsel, at Father's request, reached out to the department, and the two became connected, right?
They did not become connected, and that's part of the issue, Judge, is that counsel did reach out to the department, and she said, here's the information I can give you. Please reach out to my client. He wanted visits. He wanted to work with the department. He wanted his action plan. And what did the social worker do in response? She waited several more months before even attempting to contact the jail. She contacted a number, didn't get a response, and instead of following up, she just kind of threw up her hands and said, well, I tried. And that was all between, I believe, October of 2023 through January of 2024. And now we've got 6 months before the trial even starts, and she does nothing, does absolutely nothing. And then suddenly the trial starts, and she's like, oh, wow, now I have a contact again. Oh, now I know how to do it. And now there's a visit scheduled during the trial. To say that the efforts were disingenuous is, I think, an understatement here. I think this is a case where Father was trying his best with what he could do, and where the department kind of, well, he's in jail, he didn't talk to us before, so we're not going to give him the time of day now. And I don't think that the policy behind care and protections, behind Chapter 119, supports that. I think it's contrary to what this Commonwealth should be doing for families. And I think that had the department made an effort to truly reach out to Father and work with him instead of just kind of doing these we're going to just check these boxes for Father. In the trial session, if you're talking to the Department of Children and Families, they don't want parents to even just check boxes, right? Oh, I did this service. It's about insight and actually trying and really making that reasonable effort to be better. And I would submit to this court, Father did those things here. And it was the department who said, well, you're in jail. We don't know when you're getting out. It's not really our problem. We're not going to focus on you because you're in jail.
Well, so one of the things, focusing on the time that the father was incarcerated, one of the things that the department was looking for from him was a plan for when he got out, how he would parent the boy. And my memory of the record, and correct me if I'm wrong, is that he submitted that he would live somewhere in New York and the child could take advantage of services wherever that was in New York. Am I misremembering that?
No, I don't believe so. So I know that when Father testified, he was still incarcerated at that point during his own testimony. He had not yet had the information about specifically where he would be or what that would specifically look like. I think he was aware that he would be residing alone and under his parole terms, but that he didn't know exactly where that would be. Again, this is all also prior to any conversations between the department and Father about here are the resources that maybe are in that, because that's part of the department's job, and the ongoing social worker's job is to help parents find those resources in whatever geographical area they're going to be residing in to set those things up. So if DCF isn't talking to Father and doesn't know or is not looking into, hey, what are available services for this child, how can Father answer that when he's sitting in jail and may not know where to look yet? All of that goes back to what efforts the department make to help this father. And I would say that, let's see.
Both, you still have a fair amount of time, but both of your brethren on the other side say that the reasonable efforts argument was waived. What is your position on that?
Well, I would say that if my brief was solely based on just reasonable efforts, didn't happen, overturned, such as in Walz or Rashida, I would say, okay, that's fair. It's a fair argument. However, what I'm saying here is not just that there was no reasonable efforts, it was the court's failure to even consider the efforts made by the department in determining that it was in this child's best interest to have the father's rights terminated. She cites primarily to Father's history. She does acknowledge that Father had completed some programs while incarcerated, but she gives too much deference to the department making these reasonable efforts. And if we'd had a father who, again, was doing nothing, and where DCF was trying and was reaching out and doing all these things, that would make sense. Because when you're saying a parent's unfitness is likely to continue to a near certitude, you're speculating. You're looking at, okay, the department was trying to get father engaged in services. The department was reaching out. The department was trying to facilitate this relationship between father and child. But father wasn't doing enough, and he still failed. That's not the case here. This is a case where it's the opposite, where father was making these efforts, and it was the department who was not helping to facilitate. So how can the court speculate as to the continued unfitness of father if the department wasn't doing its part in helping father?
Do you argue that, and if so, why, that the department also failed to make those efforts before the father was incarcerated? And I understand some of that time is covered by different petitions for different children. Having said that, of course, he's the same parent, and we are entitled to consider the actions toward an older child.
Yes, so I would answer that in several ways. So first, I would say that regardless of the father's history, during this care and protection, the department's obligation remains the same during this exact care and protection petition. You don't look back and say, well, we already tried, we don't have to try anymore. With respect to the father's older two children, those are both open adoption agreements. Father recognized that it was in their best interest to terminate rights and have a different family raise these children. He did that for his children. So it wasn't that father, didn't acknowledge he couldn't raise his kids and just stopped kind of contact at all. He said, I understand, I'm not in a place to do this. I'm going to sign these open adoption agreements and do what I need to do for my children, and that was to release them. I would suggest that that first 2021 care and protection where the child was removed from mother, that it was conditional custody, so the child was only out of the home from mother for, I think, like a handful of months, from December to, I think, early spring. So even there, if father is supporting mother's custody, he may not feel he needs to do much because mother is doing what she needs to do to take care of their child. And if she's the primary caretaker, then that's what he is agreeing to. He believes his child is being taken care of. It wasn't until this current filing, the July 2023, that the child was immediately removed from mother, not placed back with mother, and that father potentially became aware that my child may be adopted out, I need to do something, and he did something. And I don't think that it's fair, and I don't think that it fits the policy of the care and protection statutes to say that, well, too bad, Dad, you're in jail, there's nothing you can do. Otherwise, we wouldn't have the requirements for the department to be working with incarcerated parents. We wouldn't have the requirements that they facilitate even virtual visits. All of those things could have been done here and weren't, because father was written off because of his history and because he was incarcerated. And I don't think that this court should uphold such a ruling and judgment.
I'm just curious, if counsel's appointed here, made aware of the efforts to communicate, I'm just trying to put myself in counsel's position. Wouldn't I follow up on that and see if there's been communication? And if there hasn't, you have a pending care and protection case, and you file something with the court to sort of alert everybody to the fact that, there's a problem here, there's a lack of communication. DCF has got to do something, otherwise my client's, going to be prejudiced here.
Yes, there are certainly avenues, and I can't speak for trial counsel as to why motions were not filed, but I know that there were court reports that are filed on a tri-monthly basis. They do permanency hearings, they have status hearings, conferences every 3 months or so, where the department files reports with the court saying these are the efforts that we've made. In those court reports, the department just repeatedly says, I'm making efforts to reach out, I'm not hearing back, I'm making efforts to reach out, I'm not hearing back. Which by April, of course, is not true when they filed their April court report, because at that point, they had not even corresponded with the jail since January. So during that 3-month period, nothing had been done, and yet the department was still reporting otherwise. So I understand if my argument was based solely on reasonable efforts, yes, that may have been waived because it was not properly raised before the court, but this is not like an accommodations request either. It's not the department didn't know, we didn't know that he was in jail and that we couldn't reach him. We didn't know that there were all these other burdens to kind of jump over and hoops to jump through. We didn't know that. They did know that. The social worker was aware of how difficult it was, and she didn't call the main number to say, hey, I'm having trouble getting a hold of this person. Who do I call next? Hey, I'm a social worker. I need to meet with my client, but I'm having trouble getting a hold of them. Who do I call next? And from father's perspective, he sent these letters. He testified that he sent multiple letters to the Pittsfield office, had no response, sent multiple letters to the Boston office, no response. So for father, he's sitting there in jail and he's saying, what am I supposed to do? No one is contacting anyone. And then he finally hears from his social worker, and I believe it came in for his understanding, that she had spoken to the ongoing worker at least one time and was waiting for that worker to report back, and nothing happened. So from father's perspective, he's being written off. He's done what he thought he could do, and what can he do now? And again, I cannot speak for trial counsel's lack of motion. I don't have an explanation for that, but I do know that my client did what he could do, and that the department certainly did not. In all of those pages of findings, the department did a handful of maybe some sort of little bit of a try, an attempt, and said, well, dad's incarcerated anyway. And I don't think that we can allow for that type of response from the department to stand. And I think that this case is a good one to say, no, when you have a parent who is trying, you need to make efforts despite their being incarcerated, because these are their rights, these are fundamental rights, and we have to do what we're supposed to do, what we're obligated to do under the law, regardless of whether the parent is incarcerated or not.
So remind me, you represented, he sent numerous letters, I think 5 letters total.
I believe so.
But the judge, did he find that, or did he find that only one was sent?
I believe that the social worker testified to having received only one, so I don't know that the judge gave much credence to the father's testimony as to that, but I know that father did, and I don't know how father would prove otherwise if he's mailing these letters. I mean, he told the court investigator that he'd been trying to get a hold of the department as well, and that was far back as December of 2023. So it's not just the father's statements to the court while testifying, he'd reported the same thing to the court investigator. And if no further questions, I'd rest
All
my
right.
brief. Thank you.
Thank you so much.
May it please the Court, Assistant Attorney General Alexander Weiss for the Department of Children and Families. The termination order should be affirmed for 3 reasons. First, father's arguments are all waived. Second, the department did make reasonable efforts to reunify father with child. Third, even if this court finds that reasonable efforts were not made, there is clear and convincing evidence in the record that the termination order was in child's best interests. Much of that evidence is not disputed by father, including his extended history of substance abuse, domestic violence, and criminal activity, as well as periods of incarceration and homelessness, all of which interfered with his ability to be a caretaker for his children. I'll start with my argument on waiver. A reasonable efforts claim was not made prior to this appeal, and all of father's arguments hinge on his reasonable efforts claim. Under adoption of West, a reasonable efforts claim needs to be made in a timely manner in order for it to be considered by this court. And there's a reason for that. The department here did not have an opportunity to adjust its accommodations in response to father's arguments, nor did the department really have an opportunity to rebut father's arguments during the termination proceeding, because these arguments were not made at that time. So for all these reasons, because the reasonable efforts claim was not made in a timely manner, this court should affirm the termination order on that basis alone.
And what is your reading of timely manner under West and other cases? Is it before judgment, essentially?
I would say it's actually before the termination proceeding. In matter of Gregory, the Supreme Judicial Court case, the Supreme Judicial Court stated that an inadequate efforts argument cannot be made for the first time during the termination proceeding. However, in this case, it was not even made during the termination proceeding. In West, this court really explains that the point is it needs to be made at an early enough time such that the department has an opportunity to respond to the argument and adjust its efforts. And here, the department had no such opportunity. Even if the reasonable efforts argument were not waived, the department did make reasonable efforts to reunify father and child. I disagree with some of counsel for the appellant's characterization of the record here. First of all, while father's counsel did make contact with the department in both August and October of 2023, Counsel did not say anything about father wanting to meet with the department, did not say anything about father wanting visitation or further services. Rather, all counsel did is ask that the department look into father's cousin in Virginia as a resource for the child, and the department did just that. The department soon afterwards initiated a home study in order to look into that as a resource, and that's currently where the child resides. Further, I want to note there is a lot that father could have done but didn't do during his incarceration. Under adoption of Yelena, the department's reasonable efforts duties are contingent on father substantially fulfilling various parental obligations. Father, first of all, did not maintain contact with the department. He sent a letter to the department once, and right after that, the department tried to make contact with him by reaching out to prison officials, but the department's efforts were impeded by the unresponsiveness of prison officials. But further, the department, father at no point requested visitation with the child, at no point requested that the department provide additional services. Father, as was mentioned earlier, father also did not establish that he had a parenting plan. He was released from prison in August of 2024. He was on probation. His probation started then, and his probation was going to last for 3 years. He had no concrete steps for how he was going to provide for the child's various specialized needs, including medical, behavioral, and educational needs. He had he couldn't establish that he would be able to provide the child with stable housing. He also didn't provide any proof of the services he claimed he received while he was in prison, and the court took that into account. When he met with the department in July of 2024, he told the department that he was going to provide various certificates to prove that he took classes while he was incarcerated, and he never provided that proof. Further, it's not true that the department didn't make any efforts to reach out to him. Beginning in October of 2023, when the department learned of how to make contact with father, because father's counsel reached out to the department made persistent efforts to reach out to prison officials throughout 2023 and then in the beginning of 2024. However, the department's efforts were consistently impeded because prison officials were not responding to the department. Under matter of Walt, when the department is making efforts and those efforts are failing because of for reasons outside of the department's control, it's unreasonable to expect the department to keep making those efforts. And here, it was unclear what the department was supposed to do when prison officials simply
This is where, as I'm reading it, this is where I'm wondering if you have a pending care and protection case, why can't DCF report into the judge the difficulties of making the contact? So at least that there is some indication, okay, we're having a problem here, and maybe the judge has some suggestion or, I don't know, some process that can be used to get through the prison officials in another state so that communication can be established.
In this case, the termination proceeding began in July of 2024, and the department actually was able to meet with father in July of 2024. So I would say there was no reason in this case for the department to make such efforts because they were able to meet with father at that point in time. And when the department met with father then, they tried to engage with father about his action plan, about his parenting plan, and asked for proof of various services. So at that point, the department was able to reach out to father. I also want to note the department took other steps to try to reach father other than reaching out to prison officials. The department asked mother to tell father that they were trying to reach him. We know that father was consistently calling mother. Father also had the contact information for the department and was not reaching out to the department during this time. The department also repeatedly sent father's action plan to him and took steps to make sure he received the action plan, including by giving the action plan to father's attorney during the foster care review in December of 2023. I also want to just put all of this in context. The department has had a relationship with father going back to 2012. Since at least 2017, according to the court, and I think this is supported in the record, the department was consistently trying to reach out to father, trying to get him to engage in services, trying to get him to a place where he could engage in supervised visitation. And father consistently avoided the department, for the most part did not engage in services. At many times, father was unable to engage in supervised visitation because of his ongoing issues with substance abuse and because he was in and out of incarceration. I also want to note that throughout all of this time, father did not at any point request the services that he is now arguing the department should have provided. There is no indication in the record that father ever requested that he had visitation with child, either prior to or during his incarceration. Father also never requested that the department tailor its services to his particular circumstances. Under adoption of Varick, that undermines father's arguments. To some extent, it is the parent's responsibility to request services that they are seeking. In addition, even if this court finds that the department did not make reasonable efforts, there's nonetheless clear and convincing evidence that the court's determination that father was unfit to parent child is supported. The court took into account many factors, including a father's insufficient knowledge or practical understanding of child's specialized needs, father's history of homelessness and otherwise unstable housing, his history of incarceration, his consistent failure to cooperate with the department or engage in services despite his ongoing substance abuse issues, his history of substance abuse, his criminal history. I would also emphasize father's history of domestic violence. There are several incidents where father committed acts of domestic violence against mother, including when at least one of his children was in the household and he was a caretaker for his children. The court put a lot of emphasis on that. Father argues that he didn't have an opportunity to forge a meaningful bond with his child because of the department's inadequate efforts. I would emphasize that father had ample opportunity to meet with child, but didn't, largely because of his issues with substance abuse. Throughout 2021, father was not engaging in supervised visitation. He was not cooperating with the department because of his ongoing issues with substance abuse and because he was having issues with law enforcement, which then led to his incarceration in 2022. Yeah, I'll end there. Thank you.
Thank you very much.
Thank you.
Good
Members of
afternoon.
the panel, may it please the court, Nicole Paquin for the appellee child who asks this panel to affirm the order of the juvenile court. Now, unless the panel has further questions about reasonable efforts, I would like to focus more on the best interests of the child who I represent here today. Termination of father's parental rights is in the child's best interests. The focus of these care and protection actions must be the welfare of the child. The parents' rights are secondary to the welfare of the child, and the judge must, regardless of reasonable efforts, make an order that is in the child's best interests. And given the father's history with this particular child, as well as his lengthy history with the department, but with this specific child, termination is in the best interest because even when father was not incarcerated and the child was not in the department's custody, when the father would have had the greatest opportunity to engage with his child, to see his child, to parent his child, he chose not to do so by and large. So child was born while the father was incarcerated. He was released a few months later in October of 2019 when the child was about 5 months old. In the next 15 or so months, while the child remained in mother's custody, father hardly saw the child. The testimony, the evidence is that up until at the time of trial, father had last seen the child when the child was 1 year old. And so he had ample opportunity to step in and parent the child. He chose not to do so. In 2021, when the first care and protection action was filed, it was filed in part because of medical neglect. And at that time, father was barely seeing the child and reported that he had no concerns about the mother's parenting of the child. And so to say that child should now be somehow returned to father, child who has all of these special needs, behavioral, educational, and medical, there's no evidence that father would ever be able to meet those needs because the child was not being properly taken care of back then when the father was not incarcerated, could have successfully parented his child, but chose not to do so, or was just simply unable to do so. He, in 2021, when there was a conditional custody order to mother, father was only allowed supervision with supervision because of concerns that he was unable to be trusted with the child. Even still, he remained largely out of contact at that time. In 2022, while father was incarcerated, father never requested visits with this child. The child, by 2023, was calling his mother's boyfriend daddy. That was the father that this child knew. And then in 2023, when the second care and protection action was filed, father's still in prison, he again never requested visitation. So the judge was correct in finding that the child has no meaningful bond with his father. In addition, the child has special needs which the father cannot meet, but which are met in his current placement. The current placement was requested by the father. It's the father's cousin. The court ordered that father will have 2 visits per year, which quite frankly is more visitation than father had had with the child since the child was 1 year old. So this is what the father had originally requested. The child at the time of trial was doing quite well, had settled in recently at the time of trial into his current placement, where he had the correct services, was in school. He's stable there, and this child deserves permanency. Right? Instead of giving the father endless opportunities to finally step up when there is zero evidence that father has changed, right? He should not be given endless opportunities, especially where, at the time of trial, father had once again failed to follow through for this child. At the time of trial, father had not reported his whereabouts to the department. Department was unable to locate him, and despite saying that he wanted custody of child, had never even asked to see him. So seeing that I am out of time, if the panel has no questions,
We do not. Thank you so much for your argument. Thank you all for your briefs. The case is submitted.
Thank you.
The last and final case on our docket for today is number 24P1418, SLV Bridgewater PO LLC versus Town of Bridgewater and others. Counsel, whenever you're ready.
Good afternoon, Your Honors. Jason Pithy for the plaintiff and appellant, SLV Bridgewater PO LLC. May it please the court, the issue has been briefed extensively. The record appendix is large enough that I didn't carry it with me here today, so I won't dig into those issues too much, other than to raise what I think are the 4 major issues why the judgment of the Superior Court on the motion for summary judgment needs to be reversed. Number 1, and these are not in any order of preference, but number 1 is that the Superior Court never even mentions the fact that due to the fact that the nature of this action is an enforcement relating to a violation of a zoning bylaw, that the burden of proof was on the defendant and not on the plaintiff. That the court also never bothers to make any findings of fact as it relates to that burden of proof. Doesn't even mention it, doesn't even consider it. Secondly, the Superior Court erred in its application and distinction of...
Well, this is all de novo review, right?
Excuse me?
This is all de novo review, right?
Correct.
So what the Superior Court did really is no moment, really, right? I mean...
Sure, but the Superior Court's findings were based upon the record that was before it. And if the Superior Court is making a finding as to the enforcement action...
In other words, what I'm saying is we really don't have to focus on anything the judge did or didn't do. It's more, okay, why are you entitled to relief, right?
Correct,
okay.
Correct. And I'll tell you.
Okay.
And I think the major significance is that the definition of the word lodgings, the lack of the definition of the word lodgings, and that's the key reason why the College Hill of Worcester versus Worcester case is the key case in this situation. And the lower court in that matter said, no, Bonaventura, which Worcester versus Bonaventura governed. Well, Worcester versus Bonaventura related to the court's interpretation of Worcester's bylaw on lodging house regulations. College Hill Properties related to the lodging house statute. However, what the Superior Court does in its interpretation and simply relying on Bonaventura and completely not using College Hill Properties is by making an inappropriate finding that, number one, Bonaventura didn't deal with the lodging house statute at all. That's not accurate. And number two, that College Hill Properties only dealt with the lodging house statute because there was no zoning bylaw. Again, incorrect. And number three, that the term lodgings was defined. The reason that the College Hill Properties case gets into such depth as to what a lodger is versus a tenant, which is what should have happened here in this case, is because lodgings is not defined. It's not defined in the bylaw, and it's not defined in the Commonwealth of Massachusetts lodging house regulation, which is exactly the same situation that we have here in Bridgewater. Bridgewater has a lodging house regulation. It does not define what are lodgings. It defines a lodging house, it defines an exception to the lodging house, and then it later defines a dwelling, but it doesn't define what lodgings are. And we would submit that clearly there is a distinction that exists between a lodger and a tenant. A tenant are the people that are occupying the property that my client owns in Bridgewater. A tenant has possessory rights. A tenant lives in an apartment. This is not what the town of Bridgewater has attempted to do is just ignore the apartment nature of this building, call it a lodging house. Well, I'm sorry, call certain apartments within this building lodging houses, because not all of them, and they would admit that not all of them are in fact lodging houses, because certain of them don't apply.
But let's assume you're right.
Sure.
I'll save you some time. Let's say you're right about that, in that we're bound by what the SJC has described as lodgings, and these are tenancies, these aren't lodgings. But in that case, in the City of Worcester case, the SJC did say at the end, such concerns are better addressed through enforcement of applicable zoning ordinances and provisions of the sanitary code and fire safety codes. So does Bridgewater have the right, under its bylaws, and whatever terminology they use, whether it's lodging houses or something else, do they have the right to say, listen, you can only have up to 3 people who are unrelated living in one of these units, or in one of these, I guess in one of these bedrooms. No, I guess it would be in one of these units. You're only allowed up to 3.
That's correct.
Do they have the power to do that?
They have the power, sure. Do they have the right and to enforce it in this manner? No. Because what happens in a situation such as the present one, so I guess let me first go back. The lodging house bylaw kind of comes out of this concept that we don't want to have a home where there's 1 bedroom, 1 bath, and there's multiple people living in that home unrelated to one another, right? It stems out of the 60s. I wasn't around then, but I heard that it was a good time, but that's where it stems from, right? So what the issue is that, and that use and that restriction is certainly appropriate. Bridgewater should be able to do that on a with regard to lodging houses. If there are properties in Bridgewater that are single-family constructions that have more than 4 or more people that are unrelated to the legal owner of the premises and don't fall within the category of a family, yes, they can restrict against them. But when you get into an apartment is a quite different thing. And again, it also goes to this whole idea is which of the apartment units are in fact the lodging house, does the lodging house regulation apply to? And we know for a fact it doesn't apply to the 1-bedrooms. The 1-bedrooms only have 2 beds in them. We know that for a fact. We also know for a fact that it doesn't apply to the affordable units because the affordable units are not subject to the comprehensive permit. Number 3, we could also know for a fact that if there's a 2-bedroom and it's only occupied by 3 people, that doesn't apply. So it's as though the occupancy associated with these particular units is what then triggers the town of Bridgewater's enforcement action. And that simply it's absurd. It results in absurd and selective enforcement, which is what the SJC said. We don't want to enforce a zoning bylaw that's going to result in such a thing. And as they said in the Sang-Vo case, I believe it was, on the one hand, we could have a unit that is occupied by 4 people that are related to one another by blood. That would be, well, that's technically not an exception to Bridgewater's bylaw. But let's say, for example, there was 4 people that were a family, right? There was a mom and a dad and their child. They're not related, they're not married, I'm sorry, but they would comply. And they have a 4th child that lives with them as well. Again, they fall within the family exception. What happens when the 4th child moves out and somebody else moves in because they need another person within that unit? Suddenly, it's now a lodging house according to Bridgewater. Suddenly, it's subject to this exception, this regulation that the town of Bridgewater seeks to enforce. And I would submit that that can't be how the law can be used. The zoning bylaw enforcement as a result is absurd and it's selective and it's simply not what we would be promoting.
Now, SLV didn't ask for summary judgment.
We did not.
All right, so if we were to agree with you, then what would you be asking for?
That the case be remanded for a trial on the merits of the case.
And are there issues in dispute at trial?
Absolutely. There were 3 major issues that were not handled at all by the lower court. Number 1, the court makes reference to what is called, what we refer to in my papers as the representative lease, the lease clause, and then the Cube 3 plans of record, okay? During the course of the approval process, SLV presents to the town of Bridgewater a representative lease. That representative lease identifies that the occupancy in these bedrooms would be multiple occupancy, such that a 1-bedroom would have 2 people in it, a 2-bedroom would have 4, a 3-bedroom would have 6. That's in the record of the ZBA proceedings. The court mentions its existence and never goes any further than that.
But so what is the relevance of that? I mean, you cite in a number of places in your briefs to things that were either submitted to the town or, publicly published that to me, and tell me if I'm getting this wrong, seem to all sort of say, listen, they were on notice of how we were going to use this property. Assume that that's true. What's the legal relevance of that?
It's an implied waiver, Your Honor. If the town of Bridgewater is made aware of the fact that this 58-unit apartment building that they went through a 2-year process of approving was being constructed, and they're aware of the fact that the plans themselves show multiple beds in each one of the bedrooms, they're aware of it, and they don't raise that issue. They don't at any point in time say, hey, we believe you need to seek an exemption from the lodging house regulation that we have in town, which, by the way, they had already determined that they don't approve lodging houses going forward anyway. So that's number 1. Number 2, if at any point in time, we were always of the opinion that the lodging house regulation simply just didn't apply.
Right, because these are apartments.
Correct, because it's an apartment building, right? And this is an apartment, it's not a lodging house. It's not lodgings, we're renting. These are tenants, landlord and tenant relationship. So the implied waiver that exists by virtue of the representative lease, the lease clause, and then possibly the express waiver that exists by virtue of the Cube 3 plans. The Cube 3 plans are presented as part of a notice of project change that's submitted after the approval of the permit, but before construction begins. And those Cube 3 plans specifically delineate the number of people that will be living in this building. Anyone that is good at math, not me, but anyone that's good at math can look at those set of plans. And you can also see on the plan itself that the fact that there's 2 beds in each bedroom, that the occupancy was going to be over 200. It was 258 was the occupancy.
But there's nothing about those plans that says that the people living in, Unit 303, all 6 of them aren't related to each other. Now, I understand that it's relation to the owner, which is a whole other thing, but
yeah, I would agree with
it
that.
could be a family.
Correct. I would agree with that. There's nothing in the plans that show that, but the plans are part of the record. And my brother's own submission makes reference to the fact that the comprehensive permit says that if there was not a waiver in the comprehensive permit, or it's not in the plans of record, it doesn't apply. Well, I would argue that if we got a chance to try this case, that would be part of the factual argument that we'd be making, that the Cube 3 plans that we'd presented by evidence from my client testifying as he participated in the process, and he would testify about what he presented, who said what, who responded to what. One of the major issues that exists as well is that Bridgewater, none of the members of the Zoning Board of Appeals were able to provide any contradictory facts whatsoever. Their answer to every piece of discovery was, we don't know, we don't recall, we weren't there, we don't know, we aren't aware of other properties that this would apply to or what have you. So all of those issues result in the fact that it's appealable. And Your Honor hit on the final point I guess I would like to make.
You still have 2 minutes and 17 seconds.
Okay, great, thank you. Well, I might be long in the tooth with this final point then, is the fact that compliance with this lodging house regulation was left completely, we couldn't do it because of the fact that SLV's status as a limited liability company rendered it completely impossible. It's completely impossible. If we read this lodging house regulation correctly, which it's no more than 4 people that are not related to the legal owner of the premises, not related to one another, but the legal owner of the premises, or fall within the category of family.
Let me ask you a couple of quick procedural questions, and this might just be for my own information. I'm just kind of curious. One is when it comes back to you, when you find this problem, is there any thought of just going back to the ZBA and saying, hey, look, we want to amend the application. This may have been an oversight, may not, but there's a question being raised now because they seem to be, it was full-throated support for the 40B project at point A, and then suddenly we're at point B, and they seem to be taking a different position. So was there a thought of going back to the ZBA?
There is a thought of that, yes. I don't know, I didn't handle any of the 40B related stuff, and I don't know as I stand here whether or not there's an ability to seek an amendment to the comprehensive permit, but that is one of the discussions that we've had, especially along the lines of the fact that recently, our largest tenant right now is Bridgewater State University. And we believe that part of the reason that this issue came up so late in the process was Bridgewater State University wasn't happy with the idea that we were building this 58-unit building. Now, we house up to 40% of 40% of the units are being housed by Bridgewater State students.
One quick question.
Sure.
Housing Appeals Committee. The Housing Appeals Committee, the state for 40B, jurisdictionally, does this not have to go before them as an appeal, or you have the option to go to Superior Court?
We have the requirement to go to Superior Court as it relates to the fact that the cease and desist order was then appealed to the town ZBA. The ZBA denied the appeal. We had to bring that action before the Superior Court. I don't believe that HAC has any authority to hear the appeal of a cease and desist.
I see. Okay.
Justice Smith has a question.
Just briefly, summarize earlier, you were stating that essentially the town was on notice.
Correct.
Due to the Cube 3 plan.
Correct.
And you stated what you would prove up at trial, why it should go back. And everything you stated you would prove up at trial about Cube 3, that is contained, is Mr. Englert's or Mr. Who's that?
Mr. Engler, yes.
That's contained in the affidavit, correct? So that was before the judge, correct?
That's correct.
Very good, thank you.
Thank you very much, Your Honors. Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
Jason Rollins, I represent the town of Bridgewater in the matter. To fill in some of the gaps that we just heard, this case is distinguishable from that in College Hill Properties for a few very important reasons. Primarily, Bridgewater has an extensive lodging house regulation built within its town ordinances and bylaws. That regulation essentially says, first and foremost, no new lodging house is permitted in the town of Bridgewater, and that's in the table of uses, which you'll find in your appendix.
But if the SJC has told us now what a lodging house is and what a lodging house isn't, whether we're talking about the general laws or bylaws, aren't we bound by what the SJC has told us?
In this case, no, and I will tell you why. I believe that the SJC in the College Hill Properties case was shedding light on Chapter 140. So there are two things at play here. Massachusetts has a statute that covers lodging houses. It is very, very sparse, to say the least. It essentially lays out what a lodging house is. Interestingly enough, it actually doesn't make exempt from what a lodging house is a dormitory, which you just heard at the end of the argument is essentially how this 40B is being treated now.
Well, I mean, I've lived in dorms, it's been a while, I'm pleased to say, and I've lived in apartments, and they have a really important difference,
Yes.
which is also one of the differences between a lodging house and an apartment, which is in a dorm, you don't have your own bathroom in your unit, and you don't have your own kitchen in your unit. I've looked at the plans here, they're apartments. They have kitchens and bathrooms. So are there apartment buildings in the town of Bridgewater?
This is probably, I'm just going off of the top of my head, this is probably the largest quote-unquote apartment building.
But there are 3 families, for
But-
example.
yeah, of course,
2
but-
families, right? And those are apartments. Does the lodging house, does Bridgewater, the town of Bridgewater, apply the lodging house
Yes,
regulation to those
Yes.
apartments?
yes.
So there's no apartment in the town of Bridgewater that contains more than 3 people who are not related to the owner by blood.
I couldn't answer that question. Are they allowed to operate that way? No. So when you ask, are there, I don't know, right? I'm not the building inspector. I don't go door to door and check on it, but they're not allowed, right? In our lodging house bylaws are actually exactly what the court is talking about in Worcester v. Bonaventura, and that the court kind of footnotes in College Hill. Because in footnote 10 of College Hill, the SJC says, hey, look, the thing here is that this isn't about a bylaw. You're actually arguing about 140, which is my point. They're relying on a holding of a case that relates to the statute. There is no, first and foremost, constitutional challenge or challenge that I know of relative to our bylaw in this case at all. I think this is a 40A Section 17 zoning appeal. I understand the legal argument. I understand that they're making it because they're saying, you know, the judge erred as a matter of law. But that's not actually the argument here. And I actually don't think there are any disputed facts here. I think the law is pretty clear cut. It's not being challenged. We actually talk about, and we're very specific in our bylaws about what a lodging house is, and we say, and this is section 2.72, it's Record Appendix 1, page 181, and it says a house dwelling unit where lodgings are let to 4 or more people or persons not within the second degree of kindred to the legal owner of the premises and who do not fall within a definition of family as defined in section 2.51 of these bylaws. Then we define family, but then I think this is probably an important distinction here where we actually go on to define what a dwelling is. And I think that was kind of Your Honor's point about, well, that's an apartment.
Well, a dwelling is clearly an apartment, right?
Exactly.
So
and that's what we're
I just
saying.
want to make sure I'm following you.
Yes.
So you are arguing that the Bridgewater bylaws definition of lodging house
Yes.
includes apartments and is different from the statutory definition of lodging house or lodging as explained by the SJC in the Worcester versus College Hill case?
So a couple of answers to that. As to question one, a lodging house being an apartment, our bylaws call a lodging house a dwelling. So I want to be careful because a dwelling has its own unique definition under our bylaws. So I don't want to use the term apartment. I understand Your Honor's question, but I don't want to quantify it in that way because that's not what we're following as it relates to our ordinances.
Okay, so we
So
won't
it is a
call it an
dwelling.
apartment, we'll call it a portion of a building used for human habitation with its own cooking and food storage and own bathing and toilet facilities.
Yes, then
That's
I'm in
catchy.
agreement, yes.
Okay.
And then part two of your question, if you could repeat that.
Oh, I can't remember.
Neither can I, so you're in good company. So
I think part two of my question was, you are maintaining that the town, city, what is Bridgewater?
It's called a
The
town.
municipality
It's
of
operated as a
Bridgewater
city, right.
has and may define through its bylaws, define lodging house or lodging in a way that is inconsistent with the way the Supreme Judicial Court has interpreted state law in the Worcester versus College Hill case.
I don't know that it's inconsistent.
Well, it really looks inconsistent to me, because as I read the Worcester case, which I haven't done in at least 18 hours, so my memory is suspect, Worcester, the SJC says, look, there's a thing called an apartment, and there's a thing called a lodging house, or, you know, as I always thought of it, a rooming house, right? And the difference is, in an apartment, you are a tenant, you have a lease, you have a property right, obviously for a limited time, in the space that is within your locked front apartment door that includes a bathroom and some means for cooking. In a lodging house or a rooming house, you have a room.
Yes.
Your bathroom is not within your locked room door, your cooking facilities are not within your locked room door, and you do not have a property right in that place. And I think, to my read, the SJC case does a very good job of explaining why those things are different and explaining how they're different. And so up against that backdrop of, you know, governing law from the highest court in our Commonwealth, I hear you arguing that the municipality of Bridgewater has created something called a lodging house that is not the same as the thing that the SJC has called a lodging house.
I don't know that that's the case. What we say is a house or dwelling unit where lodgings are let to 4 or more persons not within the second degree of kindred. I don't know that that contradicts the College Hill property, nor do I know that the SJC...
Well, it does as applied. I agree with you that it doesn't in every case, right? You could have 3 people living in a dwelling unit. You could have a family of 17 living in a dwelling unit.
Right.
Those things would not contradict.
Correct.
But as soon as you get 4 college students living in a dwelling unit,
Yes.
then, in your view, that dwelling is a lodging house in Bridgewater and is unlawful.
That is correct, so long as it is within its own cooking and food storage equipment and facilities, and its own bathing and toilet
Right,
facilities.
the dwelling, what I would call an
As
apartment,
long as
but you
it's a
don't wanna call
dwelling,
an apartment.
I agree with that. That notion is exactly what the town of Bridgewater is looking to prevent. And I don't think that that bylaw contradicts the holding in College Hill, because I think the holding in College Hill was relating to an interpretation of 140. It didn't say there could be different interpretations under bylaws. It didn't say there could be more strenuous or strict enforcement under bylaws. It doesn't say any of that. That's actually not what that case was about. In fact, I think the Worcester v. Bonaventure case is exactly on point, because if you read how they go through the notion of what we say is family, it's almost identical to what's written in ours. So I think when they put in footnote 10, I think the SJC was very, very intentional about that footnote, and I think it is incredibly important in this case. Footnote 10 makes abundantly clear that they are not interpreting a City of Worcester bylaw. They're making a decision based on using 140. And the reason that's important is this. Some cities and towns do not have these bylaws. They don't even address lodging houses. Lodging houses are governed under 140 because it's a licensing statute. So essentially 140 says, hey, look, if you want to run a lodging house, you need to, this is what we think a lodging house is, and you need to get a license from us. 140 doesn't say that towns can't restrict lodging houses. 140 doesn't say that towns can't take their own interpretation of lodging houses so long as it doesn't contradict and isn't preempted by state statute, which it isn't here. All 140 is a licensing scheme. So the point of 140 is to say, if you're going to do a lodging house, and this municipality does not have something on its books related to lodgings, this is what you have to follow, this is what we consider a lodging house, and this is how you license it. The good thing about Bridgewater's regulations are, we already address all that. And there is nothing statutorily that says that Bridgewater can't have a more strict interpretation than what 140 says. Again, 140 is about licensing, and it isn't necessarily about this is what the regulation is or the limitations on a lodging house. So I think while I understand Your Honor's position entirely, and I understand the holding, I think footnote 10 is critical, and I think the SJC, and I wasn't in their brains, but I'm gonna bet that they put that in there intentionally to say, hey, look, we are interpreting 140 here. We're interpreting a nuance of 140 here, but we are not saying that this is meaning on its face the City of Worcester's ordinance is invalid, because they didn't even address the City of Worcester's ordinance. They didn't even touch it. In Bonaventura, they did. They actually looked at it and said, all right, what is, I think it was family, if I'm not mistaken. You interpret family as X, and there's a constitutional challenge to that because some kids from Holy Cross want to all live together in an apartment, right? And they're not family. So Bonaventura said, well, listen, you can try to do that constitutional challenge, but there's nothing wrong with the way that the city's ordinance or bylaw decided what family is. I think it fits in concert with 140, but I also don't see anywhere in 140 that says, hey, look, you either have to, because oftentimes for municipalities, the statute says you have to adopt our statute if you want to have this. If it's not actually, if it doesn't speak to something specific, the supremacy clause never kicks in. The town can regulate things so long as it doesn't directly contradict the statute. And here, again, this is a licensing statute. 140 is about what is required to have a lodging house. It does define, it says, hey, look, it's for, I think it's almost the same definition as Bridgewater's. I don't have it memorized.
Let me just ask you this before your time is up. So if Scully Development, in the original application, it indicated that they were also looking for their 40B, that they were also looking to obtain relief from the provision on lodging houses. And if that was granted, then we wouldn't be here, right?
Correct.
Okay, now, does the applicant actually have to expressly ask for a specific form of relief, or if the application itself and all the specs indicating the living arrangements and so forth show that non-related people are going to be living in 2, 4, and 6 groups, isn't that enough? Isn't that enough to say the waiver's been granted?
Not here.
Is there a case that says that, or?
Well, I mean, I think the comprehensive permit itself says that. So the comprehensive permit actually says, under waivers, the applicant shall comply with the state building code and the town of Bridgewater zoning bylaw. So if you're a developer, you better know the exact zoning bylaw when you're going to apply for a 40B. I'm going to give you a quick reason why the idea that you're talking about is even more important here. Under 40B, when you want zoning relief, you don't go for a separate variance. So you can actually get that relief as a waiver in the 40B process. So it's even more important to point that out, because it's not going to just get pointed out for you. When you're developing something that isn't 40B, you as a developer have to go get a variance, right? Because you say, I'm not in compliance with the law, I need to go out and get a variance. So it's very obvious that's happening. This kind of got slid in there, and the way they did that was they did some plans with half walls in some of the rooms. That doesn't mean that there could be a brother and a sister in that room. I have no idea.
Right.
The zoning board doesn't know that.
Let me just follow up quickly on that. So it seems, even putting aside all of this, the rooming house questions, lodging house, all this, it just strikes me that there seems to be a genuine issue of fact here in that whether or not Bridgewater granted the relief that it thinks it granted. Because it's, on the one hand, it seems that, okay, you could look at what relief was granted. Was it expressly indicated that you could have up to 6 unrelated people living there? No. But there seems to be a question of fact because it was all put in front of the board. There was peer review. No one raised any question about it until the building inspector raises it sometime thereafter. So isn't that a question of fact that has to be resolved?
It's not, because that's like, I'd have to prove a negative, right? So we don't make assumptions, no board, the town doesn't make assumptions on how you're going to fill your units. We assume you're going to follow the bylaws unless you ask for a waiver. There's no issue of fact as to that. They never once asked for relief from the lodging house regulations. If they did, this appeal would probably be a different topic, right? So it's a very difficult question to answer because you don't actually know how they're going to fill their units until they fill their units, right? And we wouldn't have even known to issue the cease and desist if their own language themselves, which they don't contest, is, yeah, we're going to have more than 4 people. We told them not to do it. We're like, do not do this because we think you're in violation. They did it anyway. And so my point is, you actually can't assume anything about how a developer is going to fill his units until he fills his units. There is nothing in the record anywhere that indicates that they intend on not following our bylaws to a T. There's nothing.
All right.
Thank you.
Thank you very much. Your case is submitted, and with that, we stand in recess.
Thank you.